Good morning, everybody. Happy Thursday, Thursday, Friday Eve. I'm losing track of days. Welcome to the Courtroom Files Live. Good to see all of you out there today. Let's get going with Judge Glazer in Miami-Dade.
Cause for the charge. You are ordered to stay away from the Walmart store at 3200 Northwest 79th Street in Miami, Florida. You are not allowed to go to that Walmart store. You must stay away from there. Do you understand?
Yes, ma'am.
There's probable cause for the charge. Pretrial services, alternate bond, $2,500. Have a nice day. Next is Amber Collier, page 3. Good morning, ma'am. You were arrested for aggravated assault with a deadly weapon and aggravated stalking in violation of a court order. I will appoint the public defender's office for you, and this is a case from June 17th of 2025, I think.
Right.
Or June 30th. Sorry, June 30th.
It's a couple different dates. So the first incident is June 30th of 24. Then there's text messages, and then there's another incident that occurred yesterday.
Okay, I'm so sorry, but I don't see where it talks about why is it aggravated in violation of a court order. I don't see that.
I think it's credible threat, or you know what, it's charged under the provision of a deadly weapon.
It's what?
If you look at the charge, you know what, I'm sorry, Judge, you're right. I think it's a credible threat.
But it's not, what's the court order?
There's no court order. I think it's aggravated stalking based upon, let me get the actual language.
Maybe stalking. Anyway, ma'am, did you, I'm not sure which stay away order to do. Did you ever live with the victim? Do you have kids with him? All right, so no contact with the alleged victim whose initials are DH, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic communication. No email, texting, TikTok, Instagram, Facebook messaging, or any of that, the electronic stuff. Social media contact, and you must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. Do you understand the stay away order, ma'am? Thank you.
Judge, so it's aggravated stalking because of a credible threat.
You can't have both. What, they can just double charge everybody? Okay, fine.
No, Judge, I don't understand. So it's a
Aggravated assault was displaying the knife to him. She's in her car. He's in his.
right.
Although it could be also attempted aggravated assault, because I don't think she had the ability to carry it out then. Then count 2, the stalking is following him.
Right.
And then
but,
she sent him email or text with knife emojis. Is that the credible threat? I don't know.
So right. So there's the text with the knife emojis, and then she's initially stopped in June of 24 with a knife, and then yesterday it said that she was following him again. And when they took her into custody, they discovered that she was armed with 2 knives. So
I didn't see where it said yesterday.
Okay, so today, Mr. Harrington called the detective after he discovered he was being followed once again by the defendant. The defendant was discovered armed with 2 knives, taken into custody.
Okay, there's probable cause for the charges. You need to move on. Because you're
For
gonna go
the
to prison.
aggravated assault, they're not saying that she just showed it to him or held it up and threatened him at the time, Judge. They're in two separate vehicles.
I think it's just stalking.
But it's aggravated because of the credible threat
But what threat? Yesterday?
that she's gonna stab him. She's following him in her car with a knife on her lap. And then she sends him multiple emojis with a knife. And then yesterday she's following him again and they found 2 knives in her possession.
But she didn't display those knives. She's just following him yesterday. How would they know there's knives? What if she didn't get stopped? So if she didn't get stopped yesterday and they didn't discover the knives, would it just be stalking?
It may also be the credible threat because she's known to carry knives and she sent text messages with a screen full of
Okay.
knife emojis.
All right, I'll find probable cause for the charges. I'll set up on count 1
Would you want
aggravated.
to add house arrest?
Yeah, you want bond? Do you have money for a bond?
She has some money for a bond. Would you split one bond among the 2 counts?
Okay. Count 1 aggravated assault with a deadly weapon will be $2,500. Count 2 aggravated stalking is $2,500. And stay away from the victim. Ma'am, if you violate the court's order and get rearrested, you'll be locked up in jail until your trial. You understand?
Judge, would you add the house arrest?
Judge, I would ask that you not add the house.
I mean,
arrest.
I find this
Stay
threat
away.
credible.
Yes, I am adding house arrest. That's plus house arrest with a GPS monitor. It's level 3 house arrest. Stay away from the victim. I'm not gonna even, do you want a curfew? 11 p.m. to 6 a.m. curfew. These facts here are concerning to the court. Good luck to you, ma'am. And if there's no issues, you can ask the division judge to remove the house arrest monitor if there's no issues for the next couple of weeks. Good luck to you. Next, we have Elio O'Neill, out of turn for corrections, possibly page 4. We're waiting on your lawyer, ma'am. Go have a seat. Do you speak English? Okay, thank you. Elio O'Neill, page 4. Anybody coming up?
They're bringing him in, Judge. This should be a 2nd-degree misdemeanor. Mr. O'Neill's here. Hi, Mr. O'Neill. Come on in, sir.
Good morning, Mr. O'Neill. You were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you. So,
the
sir, there's no
defendant-
value, no mention of petty, no mention of prior state. You have something?
Yeah, actually, no, 1 second. That was not the right one. Give me one-
Also, sir, you were ordered to stay away from the public supermarket at 601 Northwest 2nd Avenue in Miami, Florida. You're not allowed to go to that store and you must stay away from there. Do you understand?
Yeah, Your Honor, could you give me a chance to take care of my mom, 95 old, give me ROR, please?
So there's
Let me
a
see what-
felony petty theft VOP out of Broward County. His probation was revoked. He was sentenced to, looks like 688 days in jail. Goes back to 2018. The defendant came in on 2 misdemeanors. There are also priors out of county, states requesting a bond.
He has 2 open petty thefts. Though he came in on bench warrants. I'm setting a bond. It will be $1,000.
He takes care of his elderly mother. Would Your Honor consider a program for him?
It says here he's homeless. I'm not giving him a program. I'll make it $500. It's easier from the bond out. Post in the
Thank
bond.
you.
Stay out of Publix.
Yes, God bless you.
Good
Your
luck to you,
Honor,
sir.
and God bless them all.
For the
Good morning once again, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. All sorts of courtrooms are suddenly coming online, so a lot I think we'll be able to look at today. Let's change it up a little bit, though. We'll go to Michigan, Judge Simpson, where bonds will continue.
I have this as an AG case.
I was looking at Jeffrey Williams, Your Honor. I apologize.
All right.
Anthony Williams. Hi here.
All right. State your appearance, please.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
He's in custody.
Yes, Your Honor, we're planning on waiving the preliminary exam. I actually didn't sign the form.
No objection, Your Honor.
Anthony Williams. All right. He's waiving preliminary examination.
Yes, Your Honor.
Sir, is that a correct statement?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also do waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for September 30th, 2025, 1:30 before Judge Conkey. Bonds will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Rayshawn Dawson.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Dawson. Mr. Dawson, could you please state your name to the court?
Rayshawn Dawson. Thank you.
Your Honor, we're asking for an adjournment, please, to review discovery.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Douglas Brown.
Good morning, Your Honor. Michael Vincent on behalf of Douglas Brown. Mr. Brown, state your name.
Douglas Steele Brown, Your Honor. Excuse me. Good morning.
Good morning.
Your Honor, this is a day probable cause conference, and I'm going to request an adjournment. We still have discovery to get.
Well, where's your? Okay. Yeah, exactly. I lost you there, and I said I'm not asking Vincent. Well, October 9th work. All right.
Thank you, Your Honor.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Terrence Ginyard.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. Go ahead.
And Your Honor, I am asking for an adjournment today. I have reached out to AAG Williams on this matter. I wasn't aware that a different AG might be covering today's case. So I am just seeking an offer from them. I did just get good contact information from my client as well, so I'm just seeking a 2 to 3 week adjournment.
Without objection, I'll adjourn this to October 9th, 2025, 9 a.m.
Your Honor, may I ask that we schedule for something after the 10th? We're concerned about a government shutdown, which would mean we wouldn't be able to appear for hearings.
Hold it. That state government shutdown?
Yes, Your Honor.
Hold on a second.
Unfortunately.
But I'm a county.
I know you are, Your Honor, but,
No, I was just looking for time off. I'm just,
they wouldn't,
so you need something after the 10th, you
yes,
believe?
Your Honor, thank you.
So, well, he's out of custody. I'll tell you what, because I don't know what that means. I maybe have to read up on that. Let me go to October 23rd.
23rd, thank you, Your Honor.
Yeah, all right. October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Who else? You county?
Location, date, time. But you need to be here next, okay? And I will reach out with your new number as soon as I know. All
All
right, take care.
Yes, go ahead. Court calls the case, People versus Quentin Coleman, Ebersol.
Your Honor, good morning. Joe Simon on behalf of Mr. Ebersol. State your name, please.
Quentin Coleman, Ebersol. All right, I have before me a plea form. That's what we're doing,
Yes, Your Honor.
indicating that he's going to plead no contest to 3 charges. First charge is count 3 of larceny, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration. Also, intentionally dissemination, excuse me, of sexually explicit visual material, 93-day misdemeanor, and count 5 of domestic violence, also a 93-day misdemeanor. Upon his successful plea to those 3 charges, counts 1 and 2 would be dismissed. There is an agreement that sentencing to be determined by probation, and that's the court's full understanding of the agreement. Is that correct?
That's correct.
Your Honor, that my client's ready to enter those pleas. Because he was in custody, I read to him all of the forms and he authorized me to sign on his behalf, and I reviewed them again with him this morning.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and the truth so help you God?
Yes, I do.
State your name.
Speak up a little louder.
Quentin Coleman, Ebersol. All right. Sir, it is this court's understanding that you are going to be pleading no contest to 3 charges. Is that correct?
Yes, Your Honor.
All right. The first charge is count 3 of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, then count 4, which is the dissemination of sexually explicit visual material. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
And also then count 5, charge of domestic violence. That's a misdemeanor punishable also by 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest these 3 charges. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced by Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of intentional dissemination of sexually explicit material, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You went through an advice of rights form and had your counsel sign that on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, Your Honor.
There's a copy on the podium. Please look at paragraph 5. You understand that because you're not having a trial, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole? No, Your Honor. Has anybody promised you anything other than what's been stated here today to get you to plead? No, Your Honor. Anybody threaten you or coerce you? No, Your Honor. You're doing this voluntarily? Yes, Your Honor. And of your own free will? Yes, Your Honor. The court has been provided and has reviewed Michigan Department of State Police report for their case number 5269-25. Any objection to the court having reviewed that report?
No objection from the people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the guilt of the defendant with reference to these three charges. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of the acceptance of my plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation. You understand that, sir? Yes, Your Honor. All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
People are not, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 25th at 10:30 a.m.
September 25th, 2025, 10 a.m. before Judge Freshour.
Your Honor, may I address bond? And with that hurried date, I'm telling my client, I didn't mean to take a minute to talk one thing. About just over 3 weeks ago, Your Honor, my client turned himself in on the court, revoked his bond. He had a $25,000, 10% bond originally. He admitted violating his bond by placing his call to his former spouse, or estranged spouse. And she contacted authorities, and obviously that's how he's in. I'm asking the court to consider reinstating that bond. The amount of time he served is pretty substantial, but he knows he earned it. He wants to get back to work, and he was on a GPS tether before, and he certainly would wait to be tethered again if released.
Response.
Your Honor. I believe it's a good course discretion. I will say people are very concerned about the behavior of this defendant, not only as the basis for the offense itself, but then violating it after the offense occurred and after he was specifically told what the conditions were. This is a situation where we have no, I think it's best left up to the PSIR. We would be more comfortable with staying in custody until the report has been done. And then, of course, they can make that determination and recommendation to the court. But at this stage, there are too many concerns, and they're adding up to be an unsafe situation for this victim.
I'm going to deny your request to change his bond once certainly the pre-sentence investigation is done, and you've got a relatively quick sentencing date. Certainly, Judge Freshour can make that decision. At this time, but motion for bond reduction is denied.
And then, Your Honor, the court we have a change in address. Was that made already, or should we approach it?
Change in address of.
For the no contact.
That should be communicated directly to community corrections. Well, actually, we're going to have the no contact. If that can be provided in writing, we'll make sure that the file is updated.
Okay, there's kind of an embarrassment of riches this morning. A lot of courts going on, a lot of places we can go, so we'll probably hop around even a little more than we normally do. Let's go to Texas. Judge Stevens, say good morning to him.
Yolanda Martin, that's you, in cause number 23-41301. Ms. Martin has a prolific history, to say the least, and she is charged with the state jail felony of theft. And as you know, Ms. Martin, I think we've, because of the 20 some odd prior convictions of thefts. If you steal a pack of gum, it's a felony from here on. Do you understand? So that would deter me, I'll tell you, from thinking about doing something like that. All right, this says other hearing. I don't know what that means.
Don't either, yeah.
Other hearing. Well, let's see. The last event, it says cases reset on the other hearing docket.
We were trying to figure out this morning, Judge.
Well,
We tried to play it last time. The plea was rejected.
okay, what
and
is the agreement?
The agreement was,
proposed?
what was it? I don't even remember.
60 days jail for lesser for theft A.
Ma'am?
For the lesser included of a theft class A was the agreement.
Okay, that was based on the facts and the.
How much time does the lady have?
She has enough to cover 60 days. That's why we did 60 days.
What was the item here?
It was at HEB, Your Honor, and actually she didn't take the items. It was the person that was with her. And that's one of the reasons why we did the offer like we did or agreed to the agreement. Because it was kind of some.
Since they were both on security footage.
Well,
coming into the store with an empty shopping cart, putting 2 Keurig coffee machines of about $300 total in the shopping cart, attempting to leave the store and passing the last point of sale with the unpurchased Keurig machines. It looks like it was a team effort there.
Well, on the video sheds a lot more light on it. The person that she was with did do that, went through the checkout area and it kept rolling out. My client stepped away over to the pharmacy, came back, checked out the items she had, and then went outside.
Which was what?
Some
medicine?
Yeah, I had got the Excedrin and I had went and got told.
Who was the other lady? I guess they know who that
Yes,
is.
it's charged.
Yes.
It's charged.
What happened to her case?
I don't believe I can look it up if you can just a
You
second.
don't believe you can look it up?
Well, I can look it up. I don't believe I know right now. She has 78 days credit.
Yeah, that's why we agreed to 60 days, just to go ahead
All
and
right.
resolve this, because it was one of those things that was just, if we go to trial, a jury could honestly go either way.
23-41301 is called the State of Texas versus Yolanda Adams Martin, present with Mr. West, her attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor, we can.
Was this in the queue somewhere?
In the past.
It was,
In
it looked like
summary-
it was on 825.
In summary, the indictment alleges in paragraph 1 that on or about October 6, 2022 in Jefferson County, Texas, you committed the state jail felony of theft involving electronics of a value less than $2,500. Stand by. I think we only need to go on paragraph 1, but the problem is a class A misdemeanor is what everybody's, okay. A class A misdemeanor under section 31.03 for what the defendant was indicted for, the theft statute, it states that an offense is a class A misdemeanor if the value of the property stolen is $750 or more, but less than $2,500.
So
What do we do about that?
So we're making the class, how much is the value alleged?
it would be a class B.
Class B.
Class B.
It still goes
Hold
within
on.
the.
But I know, but still, a class, there has to be something in the record that supports a class B misdemeanor if the value of the property stolen is $100 or more,
Right.
but less than 750. We get that on the record by everybody, and then it's covered and all is well.
Just.
All right.
Yeah.
So once again, in summary, Ms. Martin, this states that on or about October 6, 2022 in Jefferson County, Texas, you committed the offense of theft. And the parties say that this is a going to be handled as a lesser included Class B misdemeanor, as a Class B misdemeanor is proven when in a theft, the value is $100 or more and less than $750 for a Class B misdemeanor. And here, there's a probable cause affidavit that states that the value of the of two cord coffee machines is were $274.98, which fit within that range of punishment. And what I'm going to suggest is, for the record, is the probable cause affidavit be submitted by the parties. I prefer by agreement, but we'll call it State's Exhibit 1. We can get and put a copy on it to the jury and submit it, move it into the record, and the court would admit it unless the defense.
No objection on. No objection.
Have you, Mr. West, on behalf of the defendant, have you had a chance to review? I know you have this probable cause affidavit. It's 1 page. Any objection? We will call that State's Exhibit 1.
No objection. I have reviewed it numerous times, Your Honor.
All right. It will be, there will be a sticker put on it, a copy made, and then we'll make it part of the record. And are the parties stipulating or agreeing that the value is within the Class B range, above $100 in value of the two cord machines, but less than $750?
So agrees, Your Honor.
Which means that is a Class B misdemeanor, ma'am, which carries with it up to 6 months in the county jail, up to 180 days.
Okay, oh, yeah.
And a fine up to $2,000, I think, and or a fine up to $2,000. An agreement has been reached here for this lesser included Class B
I may need to change that.
Yeah, I'll change it. You just can't even touch this. Oh, no. Can't even touch it without it going berserk on this machine. It's not supposed to be. Again, it's a Class B misdemeanor up to 6 months in the county jail, and or a fine up to $2,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached. Further, that you would, how much time credit does she have?
78 days.
78 days. You would be sentenced to 78 days in the county jail, given credit for all time you have served. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this indictment? And as it is charged and as prosecuted with the lesser included offense of Class B misdemeanor under this indictment of state jail felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? And because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It is look at that again. State's Exhibit 1 there. That was the waiver of appeal that you were looking at. There's Class A. There's the State's Jail 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 as well entered into evidence without objection. And this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by your attorney. All true, so help you God. Correct? Yes, speak out.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Please, Your Honor.
I will follow this agreement. And again, you are pleading guilty today voluntarily, knowingly, intelligently, and based upon discussions with your attorney.
Yes, sir.
Right. I do find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's enough evidence supporting your guilty plea. So State's Exhibit 1 admitted here finds you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included Class B misdemeanor of theft under this state jail felony indictment under 23-41301. I am following this agreement of this Class B misdemeanor. You will hereby sentenced to confinement in the county jail for 78 days. You will be given credit for all time you have served, which I understand is 78 days. Practically speaking, is she taken into custody? And we don't take her into custody, right, Dennis? And then they check her into the jail and then they say all is well. I don't know. What do we do?
No, we'll take her into custody here.
Yeah.
Check into the jail and check back out.
Yeah, that's what they bring her in, and it's just a formality, but they have to say you've checked into jail and then you come right out. So you change clothes.
Yeah.
Yeah,
And I'll
it's an
send
in and out.
over there that she has
It's an
to
in and
present.
out. And we're gonna follow it up to make sure that there's not a problem. We'll call the jail and say, this, you get the express pass to come in and out, but it has to be done that way. You have to check into the institution where you're assigned when you're incarcerated, one way or the other. So like the jail, you go in and you come right out. All right, that is all on this case. Thank you.
Thank you, Judge.
Yes, ma'am. I have Josu Gutierrez. There's a dismissal before the court.
All right, let's change it up again. This is always fun when we're able to do it. Judge Oakley.
Your Honor, before the break, if you have the time, speaking on behalf of Ms. Marshall. Victor Marion.
Mia Marshall. Good morning.
Your Honor, today is the time, set for pretrial in this matter, prosecution witness to dismiss these charges.
No.
Yes. I guess that have to accept that.
But he will. Is it all right with you if I dismiss this? All right. You have a lovely day.
Terrorizing this young lady dog.
It was worth it, wasn't it? All right.
Thank you.
Before somebody changes their mind. Who's next? Mr. Myers, come on up.
For the record, Jeff Cox, 45367, appearing on behalf of, and with Mr. Myers. Your Honor, today, so could you tell the name correctly?
Good morning.
Today is today, except for pretrial in this matter, we are requesting a bench trial.
All right. Mr. Myers, do you understand that you do have a constitutional right to a jury trial? And you understand the difference between a jury trial and a bench trial? And you're waiving the jury, correct? All right, let's figure out what the date's going to be. Now I'm cold.
But the person, you can't talk about the case at all, or not?
Well, you got an attorney, so you should get your advice from the attorney. So if the attorney thinks it's time to talk about the case, he'll tell you, but usually that's trial. I can't help you much with that because this case has got nothing to do with your impound. Right. No, the case. What we do with this case isn't stopping you from getting your car out of impound. That's between you and the impound lot. Because I didn't impound your car. You understand that? Usually they want money to give you your car back.
October 30th, 11:45.
11:45? All right, Mr. Myers, that work for you? All right. All right, we'll see you then. Heather's going to put a paper notice together and you can walk out with that in your hand.
All right, thank you.
You do know that the impound lot's probably charging you by the day.
They've been folded. That's all. I mean, the first day, it's like first week, and been in there, I called and they've been told that they're holding.
All right, something's wrong there because the PD would not be holding your car as evidence on a drove while license suspended charge.
But I don't think they'll use without license.
Yeah, but it's not because of the court case. Right. Who's got your car, sir? Towing. And they're telling you they're waiting on the court case? They've got nothing to do with this court case. Are you sure they're not? All right, Mr. Bowditch, you might talk to Mr.
It would probably be the detective.
Greco.
Hole.
Yeah.
We put a hole on a vehicle.
On a fail to stop in a DWS?
Out of that, I don't, when they did an inventory search, who knows what.
Oh, they might be waiting for some other charges to come.
There could be a whole lot.
Mr. Bowditch, if you would ask Mr. Greco if he can look into that. So if, for example, because when they take your car into custody, they being PDs, they usually do an inventory search. If they found something in your car and they're thinking there might be further charges coming down the road, they might be waiting until they see what happens there. I'm just saying, I've got no hold on your car with these cases. Okay, I don't know what it is. I'm just telling you, I have no control over whether or not your car gets released. So he will talk to the prosecutor and see if the prosecutor can figure out why there's a hold on your car. If there's anything that we can do there, we'll try it. But I'm telling you, I haven't ordered an impound and I haven't told anybody not to release it. Understood?
Is there an attorney on that screen?
Yes. Which one you want to do next, Mr. Bowditch?
We have the actor.
Oh, hold on. Mr. Myers. Are you on a payment plan with us? Are you in a position to commit to one now?
I'll start my job like literally next week. I was like 5 times.
Well, you don't have to start paying now. You just got to put it on paper. So if you want to start it, a month down the road, just get that set up today before you leave. All right?
Yeah, Mellon.
We need to file, right? Who's next, Mr. Bowditch?
We have district maintenance.
Is that what I'm saying?
Patrick? Is it Makus? Macus? How do you say it? Say it again. Come on up, Mr. Macus.
You're on for the record, Jeffrey Bowditch, appearing on behalf of Mr. Mackins. You have today, date time set for pre-trial. Let the prosecution, I remember the defendant, he's never.
Thank you.
Subject for approval. In this agreement, Mr. Mackins will be pleading responsibility for the civil infraction of impeding traffic. As it can agree to file assessed fine $350.
All right. Mr. Mackins, it says here that you're going to plead responsible to an added civil infraction. You've agreed to pay fines and costs of $350, and the misdemeanor issued on June 11 or June 1 would be dismissed. Is that correct? And is that how you want to resolve this today?
Yes.
All right. Can you pay the $350 today? All right, go downstairs, get a smile from our cashier. She'll get you out of here when she's got your money, and we'll dismiss the original charge. If you don't get a smile, come back up and let me know. 350 gets a smile. I'm gonna guess Bingle is next.
Yep. Figuring out the alpha with those labels.
Good morning, ma'am.
Your Honor, state arraignment in this matter, where you stand here. I got a chance to pre-trial this case, we're going to execute a plea agreement subject to court approval. In that agreement, Ms. Bingle would be pleading guilty to an added count, operating while visibly impaired, completely understanding the original charge would be.
All right. Ma'am, did you discuss your rights and options with Mr. Bowditch? Understood those rights? Understand the options they give you? You understand the possible penalty for the charge? Added charge. Understanding all of that, are you pleading guilty freely and voluntarily today? You're doing this because it's best for you, not because he's trying to get out of here and go golf or something silly? Right? I said something silly. August 17th, did you drive a vehicle in Belleville? Prior to driving, did you consume alcohol? Did you take a breath test or a blood test? Do you know the results? Stipulate.
0.16.
All right. Are you satisfied that I've received the facts I need to accept this plea?
Yes, sir.
So am I. I'll dismiss the original charge, ma'am. I'm going to do two things now. I'm going to send you down to my probation department to schedule a pre-sentence interview. Did you tell her how that works?
Yes, sir.
Okay. So you're going to schedule the interview. You'll find out when your sentencing date is, and I'm also going to put you on a personal bond. First two conditions are obvious conditions. No new charges and show up for the next court date. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's script. Can you live with those rules? Yes. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions? You sure? Go downstairs and listen for your name. Probation will call you up to the counter.
Thank you.
Have a nice day.
All right, friends. Well, he's between contestants. Let's take a minute and talk about the sponsor for today's show, and that is Aura. You have heard me talk about Aura many, many times over the last couple of months, and I do it for a good reason. Aura approached this channel and said, we want to partner with you, and I made them prove it to me as to what they could offer. Aura is an all-in-one solution when it comes to protecting yourself and protecting your data online. I had not used them before, and I refuse to partner with anybody that I don't understand, believe in, and would use myself. So I started using them, and they offer a whole lot of different things. Identity protection, transaction monitoring, spam and junk mail removal, an antivirus, a VPN. You name it, they pretty much have it. But let me tell you about the biggest thing for me, and that involves this phone right here. I was getting, not only on my business numbers, but my personal numbers, an inordinate amount of spam calls, just ridiculous amounts every day. It was crazy. But as soon as I started using Aura, it all started to taper off. I was getting less and less every day. Literally every day was a little less and a little less, right down to the point where right now, if I get one a day, it's weird. So they've been great from that standpoint for me. The bottom line is there are data brokers online that have all of our data, and they have no problem selling it to bad actors, and it is just one big interruption to your life. So what I recommend you do is this. Go to aura.com/TCF. There's a link in the description. Barbara has just dropped a link in the chat. You can scan the QR code. You can memorize it and type it in later, whatever it is that you want to do. But when you go there, you get 14 days for free to try it. You'll find out within 24 to 48 hours exactly what they'll be able to do for you, because they will show you everywhere online where your data is, and they will start removing it for you right away. And it makes a huge difference. There's really no excuse not to give it a try, because for 14 days it's free. If you decide at the end it's not for you, so be it. But you also may decide to become a permanent customer of theirs. Aura.com/TCF. Ellie is such a believer in it. Every time I do an Aura spot, she comes up to give her 2 cents, because it's protected her as well, hasn't it, sweetheart? Yes. Aura.com/TCF. Do give them a look. Let's go back to Judge Oakley.
You want me to bring some people in and try to find out who the hell they are?
Called downstairs and they do,
They're dealing with it.
somebody's gonna jump on.
We didn't approve that much, did we? Did we have all those people? Did we know those people were coming in soon?
Some of them are just, observers for a case. Wayne County, oh, he's bringing back.
All right, looks like they're still searching for their next contestants. Let's go to Florida, Wade Mercer.
Miss Bailey, good morning. Miss Bailey, your mother is in the courtroom. Ma'am, you're here for first appearance accused of one count of child abuse. Miss Bailey, I read the complaint. There is probable cause for the charge, ma'am. Miss Bailey, I was extremely concerned this morning because the criminal history I got is very long. But when I look closer at it, it's a different name, a different date of birth, and a different social security number. So I asked Sergeant Gross to rerun your criminal history, and he tells me that you have no criminal history. So I want to make sure that that's accurate. Have you ever been arrested or charged with a crime anywhere?
No.
Okay,
No,
all
sir.
right, perfect. All right, so Miss Bailey, let me see what the attorneys have, if they have any additional information that we're going to address your bond or your release status. Mr. McDaniel, anything on behalf of Miss Bailey?
No, Your Honor.
Mr. Mitchell?
Not this time, Your Honor.
So Ms. Bailey, you've got no prior criminal history. This is not your typical child abuse. The allegations are that there was excessive force used in the disciplining. So it's not your regular child abuse case, ma'am. For those reasons, I'm gonna let you pick between a bond and a conditional release. If you prefer the bond, some people do prefer the bond for this charge. What bond did I set yesterday on the gentleman that chose the conditional release? The football field incident, it's a very similar.
I think 2,500.
So if you wanted to,
250 cash. Yeah.
he chose the conditional release or he chose the bond?
I think he chose conditional
Mr. Bruton,
release.
his name was Mr. Bruton.
Yeah, he,
Okay, so if you want to choose I gave him a cash bond option.
yeah, you
Is there
did.
any objection to the?
Nah, no objection.
So if you want to choose a cash bond, it's going to be $250. If you want to choose a conditional release, I'm going to offer you a conditional release because you have no criminal history and because of the type of charge you have. There is going to be a condition of no unsupervised contact with this particular child while this case is pending. So I'm not going to stop all contact. It's going to be supervised contact only till we can kind of figure out what's going on in this case. Do you have any questions about your choice between the bond and the conditional release, ma'am?
I don't know what that is.
Okay, I'll be glad to explain it to you. So a conditional release means this. Well, let me explain bond first.
I explained it to you. It's what I talked to you about this morning, man. When I said conditional release and you got to call in once a week. It's $30 a month in fees. Can't use drugs or alcohol.
So you get to pick whether the bond or the conditional release, whichever one you choose. The bond's $250 cash. The only conditions of the bond are don't miss any court dates, don't be charged with any new crimes, and don't have no unsupervised contact with this particular child. If you choose the conditional release, you've got many more rules, like Mr. McDaniels explained to you earlier. You have any questions about that choice?
No.
You want to choose the bond or go ahead, ma'am.
The bond, please.
Okay, so it's a $250 cash bond. So I'm talking to your mother now. Ma'am, some people choose a cash bond because it has fewer rules to follow. You don't have to report into an officer. What you've got to do basically is stay out of trouble, don't miss court dates. And I'm allowing supervised contact with this child. That means another adult can supervise the contact, has to be present at all times. I don't want them alone until we kind of sort all this out. So as soon as the $250 cash is posted at the jail, she'll be released. And that cash bond, if the case against her is dismissed, the money is returned to whoever posted it. If the case against her goes forward and there's court costs and fines imposed, that $250 goes towards court costs and fines. So your mother's heard all that, ma'am. Her question is going to be, your daughter's question is going to be, are you going to be able to post the cash bond for her this morning? Okay, so your mother said she's going to post that cash bond and get you out of there this morning. I want to ask the jail to give you a notice for your court date. Your next court date will be in front of Judge Garcia, and that will be October the 7th at 8:30. Corporal Drown, if you'll give her notice for October 7th at 8:30. Miss Bailey, you will not get a notice in the mail. Ma'am, the notice that you get, put in your hand will be the only notice that you get. So make sure you keep up with that. And my understanding is that you turned yourself in. So that is a factor that I look at. You're obviously not a flight risk, or at least that's a great indicator you're not a flight risk because you did turn yourself in to get this issue resolved. Miss Bailey, do you have any questions?
I guess not.
Ma'am, do you have any questions in the courtroom? All right, ma'am. As soon as your mother posts the bond, you'll be released. Just make sure you make that October 7th court date, okay? Well, that's it for friends or family in the courtroom. So we can go back to the top of our list, which is Keandre Riley. Mr. Riley, good morning. Mr. Riley, you're here because you've been accused of one count of aggravated assault and one count of battery. There is probable cause for both charges. I asked the jail to get a urinalysis in your case this morning because you're on state probation, and let me see if they have that. I can't tell who's in the room. Is Corporal Drown still in the room, or
he stepped out? But there's
Sergeant Gross, any results on the UA for either of those cases from this morning?
We have not been able to get results yet.
On either case?
On either one, no, sir.
Okay. Mr. McDaniel, anything on behalf of Mr. Riley? No, Your Honor. Mr. Mitchell?
just that when we get the results, just to send it to all of us like they usually do.
Thank you. Mr. Riley, I'm going to set your bond at $10,000 on the ag assault, $5,000 on the battery, no bond for 7 days. I'm going to ask Mr. Mitchell to notify the probation office of the arrest in 23558 CF. So what that means is you've got bonds on the new cases, but you've got no bond until we see what happens with the violation of probation. If they seek a warrant, which I think they pretty much have to, then we'll see if the judge that reviews that puts a bond on the VOP warrant or not. I will see you in 7 days. We'll see if they have a warrant or not. If that 7 days falls on a weekend or holiday, I'll see the next working day, and we'll see if they have a warrant and if it has a bond on it. If you do post bond at any point, well, actually from this point forward, you've got a condition, no contact with the alleged victim in the new case or cases. And they will get a urinalysis from you after court because you're on probation. You have to submit a urinalysis. Any questions, sir?
No, sir.
Have a good day, Mr. Riley. Yeah, we do need to give Mr. Riley a notice also for the new arraignment date, which would be October 7th at 8:30. Corporal, please. Have a good day, Mr. Riley.
All right.
Brendan McClendon. Mr. McClendon, good morning. Mr. Clendon, you're here because you've been accused of one count of trafficking and one count of possession with intent to sell, trafficking a controlled substance and possession with intent to sell. There is probable cause on both charges. The warrant is incorrect. Mr. Mitchell brought to our attention this morning that the state, there's different levels of trafficking based upon the amount of the substance. They have charged you with a mid-level trafficking. What the clerk's office did, it appears by error, is issued a warrant for the lowest level trafficking. Now, they're both first-degree felonies, but there's a different minimum mandatory. It doesn't really change the bond, at least when I'm seeing the cases. It's usually a $50,000 bond on trafficking in the vast majority of cases anyway. But I want you to be aware, you're actually accused of trafficking of what, Mr.? I've got it pulled up here, Mr. Mitchell, if you don't. You're accused of trafficking 28 grams or more. The warrant the clerk issued was trafficking between 4 and 14 grams. So you may be accused of the highest level of trafficking. I'm not 100% sure about that. Let me see if the attorneys have any additional information before I address your bond status. Mr. McDaniel, anything on behalf of the defendant?
No, Your Honor.
Mr. Mitchell?
I think the highest level is 200 or more or something.
It depends on the substance.
Depends on the substance. This
Yes,
one's
I don't know.
amphetamine, so there
Yeah.
is that. But regardless of whatever his bond is, we request that he be subject to random UAs.
Mr. McClendon, have you completed your Department of Corrections sentence or you still have a few days left?
No, sir. I finished on the 23rd.
Okay, so I'm going to set you a bond because you're entitled to a bond. But Mr. McClendon, keep in mind, even if you post bond, you wouldn't be released until you finish that sentence. So don't want
Yes,
you to
sir.
get confused about that. So I'm going to set your bond at $50,000 on the trafficking, $15,000 on the possession with intent to sell. Your total bond is $65,000. You do have a condition of random urinalysis, and you're eligible to post that bond. You can post it immediately, but even if you post it, you wouldn't be released until you complete any other sentences, specifically your Department of Corrections sentence. I'm going to ask the jail to give you a notice for your arraignment date, which will be October the 7th at 8:30. That's the next time you'll be back in court in front of Judge Garcia. Mr. McClendon, do you have any questions?
This is from 2018. There's no, that doesn't matter. That's from 2018. They know where I'm at. I did a motion to order to transport in 2019, and they kept striking my motion. I did it 5 times.
I saw that. I also saw where you filed a motion for speedy trial, and I read
Yes,
that
sir.
order this morning where the judge determined that under Florida law, the speedy trial doesn't begin until a warrant is served. So typically with prison cases like you have, the state has the option of going ahead and proceeding with the prison case, the new charge, or waiting until the prison sentence is completed and then beginning the sentence. And the way they decide that is they don't serve the warrant. So in your case, what they did is they got the warrant issued, but they didn't serve it until you completed your sentence. And according to the case law in Florida, that's entirely their choice. That's what the court order said in your case where the judge denied your motion for speedy trial. But that's still something you want to make your attorney aware of when you do get an attorney appointed at your next court date, okay?
Yes, sir. Because they told me since I got charged in the state and I got in trouble in the state, I couldn't get the outside charge too because they already punished me. I've been punished for this already.
Yeah,
And
whoever told you that doesn't know what they're talking about. Florida law has been very clear. Department of Corrections can take away gain time, and that has nothing to do with external charges. That's been the case for at least 30 years. That's been the law.
On the case law, it said they got to go to the attorney general first before they do a DR. They did the DR first, then the attorney general. We pulled the
That's
case.
a different issue. That's a different issue. Now, there may be something DOC didn't do right. I'm just saying charging you outside the system has nothing to do with the punishment inside. But if they didn't follow the procedure, that may or may not be accurate. But the state clearly has a right to charge you externally for a charge that occurs in prison. That's entirely up to them. But I wish you the best, sir.
Yes, sir.
Your Honor, I did also want to add on to that point right there. Speedy trial was also suspended at the time because it was pursuant to the COVID restrictions that was going on. So that's just something I wanted to add it in if that clarified it a little bit.
That
for
was
him.
mentioned in the order also. Thank you, Mr. Mitchell. Next case we have is Angelo Lawson. Mr. Lawson, good morning. Mr. Lawson, you're here because you've been accused of one count of using a computer or device to solicit a minor to engage in unlawful sexual conduct and one count of unlawful use of two-way communication device to further a felony, 2 third-degree felonies. Mr. Lawson, there is probable cause for the charges. And Mr. Lawson, you have very little criminal history. I think of no motor vehicle registration. That's the only thing I see. Mr. Lawson, let me see if the attorneys have any additional information before I address your bond or your release status. Mr. McDaniel? No, Your Honor. Mr. Mitchell?
Your Honor, this is very similar to a bunch of the other cases that we have. Plus also the complaint mentions that the defendant allegedly admitted post Miranda to sending these messages. So we would also request that he have no use of the internet, I think, except what was the condition we said yesterday except for the use of bill pay and I guess texting.
Are you employed, Mr. Lawson?
Yes, sir. I'm a med-surg ICU nursing assistant at Northwest Florida Community Hospital, and I'm a nursing student at Florida Panhandle Technical College.
Do you use the internet either for your education or your employment?
For educational purposes and just for, like CPR trainings and other medical trainings that we have to renew, and at work, like charting, vital monitoring and stuff like that. But other than that, yeah.
You can't sign up for a class without when you sign up for classes now, it's all on the internet.
I'm going to set your bond at $5,000 in each count. You're going to have a condition, no unsupervised contact with any minor. And unsupervised means any contact, including electronic contact. You cannot text a minor, period. You can have supervised contact with friends or family members, nieces, nephews, siblings, cousins, only with adult supervision of someone responsible for that child's care. You also can use the internet for work or educational purposes only, or bill pay. So that's the terms you can use the internet for: work, educational purposes, bill pay. If you've got bills you got to pay online, you can do that, but that's it. You can't use the internet for any recreational purposes. You can use text messaging, but this rule about no contact with minors still applies. And that's the condition. So what happens, Mr. Lawson, is you'll get to use the phone in just a few minutes. You've got a $10,000 total bond because it's $5,000 each on 2 charges. If you go through a bondsman, they're going to charge you some percentage of that. Usually it's around 10%, but that's up to the bondsman and yourself. And when you post the bond, you'll be released. Just stay away from those conditions. Be aware of those conditions while you're out waiting for this case to get resolved. I'm also going to ask the jail to give you a notice for your court date. Your court date will be October the 7th at 8:30 in front of Judge Garcia. Mr. Lawson, do you have any questions?
No, sir.
Wish you the best, sir.
Thank you.
Yes, sir. And just for his benefit, I don't think he admitted to using the internet, but according to the complaint, he denied the purpose of it. The complaint, there was some defense alleged there, so it wasn't a, what I would call a confession or admission in full. Next case is Joshua Judah.
Statements. Yeah, that's what it was, right?
Yeah. It was just a little different than the normal.
Yeah.
Mr. Judah, good morning. Mr. Judah, you're here because Corporal, the jail sheet is wrong on Mr. Judah, just so we can get that clarified. You're accused of 3 counts of your third or subsequent theft. So you're accused of 3 third-degree felonies. Mr. Judah, the jail sheet's wrong, Corporal. It says 1 count of grand theft, third or subsequent. So it's actually 3 different charges he's accused of under the same case number, 25-416CF, 3 counts. Mr. Judah, I'm going to set your bond in these cases. You're entitled to a bond. There is probable cause. There's a private attorney already filed a notice of appearance on his behalf. So, Mr. Judah, you've already got an attorney working on this case for you. In addition to the case here, you have a no bond warrant out of Holmes County. So if you post the bonds I'm about to set you, you'll be released to Holmes County. That is in case number 22-176CF. They've got a no bond warrant already issued. When I looked at it, that no bond VOP is based in part on these new charges and in part on some other technical violations. Your bond in the new cases here, because you're already on probation, is going to be $10,000 each. You've got a total bond of $30,000 then today. We've got a condition of no contact with any Walmart on today's charges. And you've got that hold I mentioned out of Holmes County. Mr. Judah, do you have any questions?
No, sir.
All right, sir. Have a good day.
Thanks.
Mr. Mitchell, you didn't have any additional requested conditions other than those normal ones, did you?
No, just also that we set him on the October 7th date. He'll be on the private attorney docket.
Thank you. We need to put in for October 7th. Give him notice for October 7th at 8:30 also, please, Corporal.
Private attorney docket.
Yes, sir.
Yeah.
Actually,
It's that afternoon. Yeah. So it's
so
the
it'd be a
same
different
day.
time.
Yeah. 1:30.
So Corporal, since he's got a private attorney that's filed a notice of appearance, his notice should be for 1:30, not 8:30.
Yes, Your Honor.
Thank you. Lorena Simpson. Ms. Simpson, good morning. Ms. Simpson, you're here because you've been accused of
Morning,
1
Your
count of battery. Good morning. Ms. Simpson, I've read the complaint in your case and there is probable cause, ma'am. Ms. Simpson, I've also looked at your criminal history. You have several prior charges, most of which appear to be alcohol related or alcohol based. But Ms. Simpson,
Your
I think
Honor.
you're entitled to, let me finish.
Can
I'll
I
give you a chance to ask any questions in just a moment, I
Okay.
promise.
I have
Okay, you're
traumatic
entitled to a
brain injury.
bond. I want to listen to the attorneys before I address that bond and see if they have any additional information that I may not be aware of. And all I'm aware of is what the complaint says, what I found on the Department of Corrections website, and what I found in your criminal history. Mr. McDaniel, anything?
Yeah, we just asked for a reasonable bond. And Ms. Simpson, I told you before, don't talk about your case. You don't need to say anything, ma'am. I know you're dying to say that your daughter hit you, but don't talk about your case.
Mr. Mitchell.
Nothing at this time, Your Honor.
Ms. Simpson, I'm going to set your bond at the normal bond of $2,500. That's the bond I almost always, not every time, but almost always I set for a battery case, ma'am, for someone that doesn't get a conditional release. You're not going to get a conditional release with your criminal history. You're just not.
What?
If you'll let me finish, I promise you, I'll give you a chance to ask questions. But I've told you, don't say anything to hurt yourself. Don't talk about the case. Your bond is $2,500 cash or surety. You have the right to go through a bondsman, and you have a condition of no contact with your daughter. You cannot go to that property unless law enforcement is with you to get your clothing or other belongings, as long as your daughter is living there. So
Yes,
just be
sir.
aware of that. You can no contact the alleged victim. Now, remember your
Yeah.
attorney's advice. Don't talk about the charges, because I don't want you to say anything that's going to hurt you. But if you have a question, and if it's a question I can answer, I'll try. Any questions?
Yeah, how long am I looking at in jail, Your Honor? I
Until
don't
you
know if
post
I'll be able
bond.
to.
If you post bond in an hour, you're going to be out of there in an hour. If you're not able to post bond, what's going to happen is you're going to be put on our next jail arraignment docket, Mr. McDaniel. When would that be?
Right.
October the 8th is the next jail, October the 8th?
Yes, I'm thinking she's gonna be on the 9/29 docket, but, oh, she's not? Okay.
She missed the cutoff today.
So,
But she'll still be up October the 8th, right? We'll see you October the 8th, if not before, if you haven't posted bond. Mr. McDaniel is really good about staying on top of the cases, and he may bring you up the 5th or 6th or 7th if y'all have it worked out. but October the 8th will be your court date unless you post bond. That is an in custody date. So the jail's going to give you a notice for an out of custody date because we don't know if you're going to post bond or not, and we're going to hope and assume you do. The court date you're going to be given notice for is October the 27th at 9 o'clock, but we're going to see you before then if you're still in jail. Now, do you have any questions?
Thank you, Your Honor.
Yes, ma'am.
God
Have a
bless
good day. We have Alyssa Chambliss next. Ms. Chambliss, good morning. And Corporal, Ms. Chambliss has not been able to give a urinalysis, or have y'all not tried that yet? Just didn't have time?
She is not able to give one at the moment, Your Honor. She peed before she came in here. We didn't catch her time.
Ms. Chambliss, you're accused of one count of child neglect, ma'am. You're also accused of violation of state probation in case 24-1294 CF, ma'am. There is probable cause for the child neglect. I'm going to listen to the attorneys, then I'm going to address your bond status. Mr. McDaniel?
That's, yeah.
Mr. Mitchell?
Not this time, Your Honor.
Ms. Chambliss, your bond is going to be $10,000 on the child neglect. You're going to have a condition of no contact with that child for now. I want to see her again tomorrow once I see the results of this urinalysis. And if depending upon the urinalysis, I may or may not. Actually, Judge Garcia is doing that tomorrow. So let's do this. If you will email us like you normally do, Corporal, with the results of the urinalysis, because she's on for drug-related offenses. If there is illegal substances other than marijuana in her system, then I'm probably going to leave that no contact in place. I don't want her having contact with that child with these allegations already on probation if she's got methamphetamine in her system or some other controlled substance. If she passes the urinalysis, then I very well may change that to no unsupervised contact. But
Probably in 7 days. Want to bring back in 7 days, Your Honor, if you just want to.
yeah, I'm gonna see you. Thank you. I'm gonna see you in 7 days anyway. So you've got that's the new charge I just mentioned on the violation of probation. I'm gonna hold you for 7 days, and I'll see you in 7 days, and we'll see if they have a warrant or not on that. So you've got no bond for 7 days. You've got a $10,000 bond in the new case. So even if you post bond, you wouldn't get out. We need to see what's going to happen with the VOP, and we need to see what happens with the urinalysis. Ms. Chambliss, do you have any questions?
No, sir.
All right, ma'am. We'll see you in 7 days. The next case is Freddie Jones. Mr. Jones, good morning. Mr. Jones, you're here in case 25415 CF. You're accused of one count of battery and one count of battery by strangulation. I've read the complaint. There is probable cause for both charges. I think you're entitled to a bond. You've had a couple of recent charges within the last year or so, but they've been dismissed. Or I think one was reduced to a misdemeanor sentence to time served in Calhoun County. So, Mr. Jones, you're entitled to a bond as far as I can tell. Let me listen to the attorneys, and then I'll be glad to set your bond. Mr. McDaniel, anything?
No.
Mr. Mitchell?
No, Your Honor.
Mr. Jones, I'm going to set your bond at $7,500 on the felony strangulation charge, $3,500 on the misdemeanor battery. Your total bond today is $11,000 cash or surety. That means you don't have to come up with all that money. You can go through a bond with Mr. Jones, and you've got a condition, no contact with the alleged victim at all. Mr. Jones, you'll get the phone in just a few minutes, sir.
Who is the victim?
Say, who is that? Okay, let me look it up. While I'm looking it up, you'll get to use the phone in a few minutes, sir, to try to post the bond. And I'm going to look it up and answer your question, the person that's the alleged victim in this case. I remember it was a female, but I don't remember the name and I didn't write it down. So let's see.
We lose him? It's his girlfriend.
Mr. Jones, the person that's
We lost him.
What you do, Don?
He knows it's his girl. He knows it's his girlfriend.
I just touched the mic. I didn't do anything myself either.
Let's try it again. Let's try to reconnect. We're trying to get Mr. McDaniel out of here.
Come on, you don't want to get him held in contempt or anything?
No, I'm fine.
Yeah, just a bit.
I feel like they're shaking.
All right, Mr. Jones, we lost you there for a second. We had somehow our connection got disconnected. Can you see and hear us okay, Mr. Jones?
Yes, sir.
The person that's accused you of this is a Carrie Quinn Scott. That's the person you can have no contact with. Any other questions?
I ain't been around Carrie in
Got a question,
Like,
Mr. Jones?
This supposedly happened in June, June 24th is supposedly when it happened. Any questions? No.
Well,
Have a
they
good day,
say-
sir.
Man,
Go ahead. If you have a question, I'll try to answer it, Mr. Jones. Mr. Jones, any questions?
Fuck that, y'all corrupt.
Come back up here, Mr. Jones. Let's get him back in there, Corporal.
Fuck that, fuck her. Corrupt ass motherfucking county man, fuck y'all. Got this big ass bullshit ass shit going on.
We're fit to have to, excuse me, Your Honor.
Oh, he's gonna come back in there. I don't care if it takes 5 of y'all to get him. He needs to be back in there. We're about to have a contempt hearing.
They're gonna, he's a fighter. I mean, they're gonna be fighting.
Oh, he can pick up another charge if that's the case.
Maybe not. We'll come back to Mr. Jones in just a minute. The next case is Tasha Sizemore. Ms. Sizemore, if you're in the room, come on up, please.
Gross in there.
Did Gross leave?
No, he's in there.
Ms. Sizemore, are you in the first appearance room?
Can they hear us?
I wonder if they've lost connection again.
Anybody in the room? I didn't see him muted. Did he walk up there muted?
I don't know, but they should be able to hear us even if you muted it.
It would say muted, I guess, yeah, so.
Does it say muted when you mute it? I don't think so.
Oh, there, yeah, we did lose him.
It stopped.
Well, that's no fun. He muted his screen, but we don't have that hold music. That hold music was great. So yeah, this is getting interesting. Not a lot of action at the moment, but I want to hang here because I want to see how this goes down. Actually, you know what? We're a couple of minutes in the Wayback Machine. I can bump us forward a little. Let's see if we can bump past some of the pause. There we go. Let's pick it up from here.
Doc, it didn't come back. All right, I think we're reconnected now. We appear to be back on record. I'm going to keep losing the connection there. Corporal Drown, can you hear me, sir?
Yes, sir, I can.
Okay. So we've got back to Mr. Jones. So Mr. Jones, I understand people being upset if they're in jail, especially if they feel like that they're there inappropriately. What I can't allow is to use that kind of language in court. So there's two things that are going to happen. Number one, either you're going to apologize and we're going to be through with it, or number two, we're going to have a contempt hearing. Which do you prefer?
Listen, I apologize, but
okay,
we all know the situation of my situation. The whole county, now probably the whole United States. And the whole time this female done been behind me, stealing my clothes, taking this and taking that, and doing all this crazy stuff. I done really stop dealing with this female, and now y'all want to come back and charge me with some shit from June. I mean, some stuff from June.
You can't use that language, Mr. Jones. Do not use that language again.
I'm sorry,
Mr. Jones. Let me tell you when the warrant was applied for. Okay, so let me give you a timeline here. So the complaint alleges that this charge supposedly happened June 24th, and the warrant wasn't issued until September 10th. Now, I believe this is a case. I don't know this, but I believe this is a case where law enforcement was looking for you for some time period to get your version of what happened. And then let's see if this was approved by the state attorney's office or not. Because some of these cases, I'll give you a chance to ask questions. I'll give you a chance to ask questions. Just let me try to tell you what happened and why this case has been sitting there so long, because that's a concern I would have if I was in your shoes. So in your case, let's see if it was in the state attorney's office or if the law enforcement was just holding it all this time. There it is right there. This was in the state attorney's office for quite some time while they were reviewing whether or not there was sufficient evidence to charge you, and presumably trying to get more information. They eventually decided there was enough evidence. They told law enforcement they had signed off on the warrant, and the warrant was signed. So there's a delay there. So I understand you being upset. I don't understand you using the language that you're using. Can't allow that. But I've set you a bond, and you've got the right to post bond, and you're going to use the phone in just a few minutes to try to post the bond. Now, do you have any questions, Mr. Jones?
Well, be in my situation where everybody done turned their back on me. So I have no family. And I talked to the police the night that Keandre got the cops called on him. So with all this being said, like something ain't adding up.
You're
Matter of fact,
gonna
ain't
be in
nothing
court.
adding up.
When's
It is what
Mr.
it
Jones
is.
gonna be in court? Do we even get to that?
I don't think so.
October 7th, but
It's
we
the
didn't get
7th
to
though.
The 7th, you're gonna be in court in about 2 weeks and you'll get a chance to have a lawyer appointed. But Mr. Jones, in the meantime, you've got the right to post a bond. That's all I can do. I'm sending you a bond, okay?
Yeah, but y'all already know my situation. Y'all already got me homeless. I know everything that's going on with my situation.
I promise you, I have nothing to do with you being homeless. I didn't even know you were homeless till you just said it.
Hey,
I wish you the
listen,
best, sir.
when Gary get back to these streets, we're gonna.
I didn't hear what you said.
When Gary gets back to these streets.
So I will say this, there are very few judges out there that have an ability to de-escalate quite like Judge Mercer does. The more we watch him, the more I'm impressed, because that could have easily gone all flavors of Kitty Wonkus, and he kept it all under control, so good on him.
Sizemore, if you're homeless, if you happen to be homeless, I promise you I had nothing to do with it. Miss Sizemore, you have a warrant out of Geneva County, Alabama, ma'am. I think you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. Miss Sizemore, do you have any questions about that process?
No, sir.
And do you want to waive extradition and go address these allegations against you in Geneva County, or do you want to contest it?
What do you mean?
If you waive it, you sign a piece of paper and they have 30 days to pick you up. If you contest it, they can get longer than that upon a showing of good cause.
Yeah.
She wants to sign the waiver, Your Honor.
Is that right, ma'am?
Yeah.
Okay, if you want to go ahead and sign that waiver, Mr. McDaniel, you satisfied she's doing this freely and voluntarily?
Yes, Your Honor.
Ms. Sizemore, they have 30 days starting today to pick you up. Ms. Sizemore, to keep track of these cases, I asked the jail to bring them back to first appearance after 15 days. For Geneva County, Alabama, that's very rare. You're probably going to be back in Geneva County within a week, but if you happen to be at our jail in 15 days, you'll come back to first appearance. I'll say, officer, what's going on with the transport? You'll get to hear the answer. I'll get to hear the answer. But if they don't pick you up within 30 days, you're released. Any questions?
No.
Have a good day, ma'am.
Thank you.
Yes, ma'am. Jermaine Riley. Mr. Riley, good morning. Mr. Riley, you have a hold out of Jefferson County, Florida. It's a violation of probation hold. It has no bond on it, Mr. Riley. That means you're going to be held for Jefferson County. Sir, you'll get transported over there. When you get to Jefferson County, you'll go through a first appearance and you may or may not get a bond, but right now you have no bond. Any questions?
Okay.
Have a good day, sir.
You too.
Thank you. Corporal, I think that's it for first appearances today, unless I missed somebody. Anything else from the jail?
No, Your Honor, I want to apologize for Freddie Jones's behavior.
I don't, unless you got him riled up before court started, I
No,
don't think it
sir.
had anything to do with that, but.
No, sir.
I
don't know who Freddie is.
If I was in jail, if Mr. Goodson was in jail, he'd probably lay a cussing on me. He cusses at me when we're in the courthouse, especially in jail. I bet he would. But
Yes, sir.
he apologized, so it's over with. Thank you. Let me see if the attorneys have anything else before we disconnect. Mr. Mitchell, anything on behalf of the state?
No, Your Honor.
Mr. McDaniel?
All right, let's stay in Florida, but we'll check back in for a few minutes with Judge Glazer.
I have a Nebia requirement for both cases.
There's no Nebia, no
Nebia.
Nebia.
On the other case, Judge, we can talk about it, correct?
Okay, the other case, what do you want to say? You said it twice. It doesn't specifically say where the drugs were found. Do you want to call up the officer?
I mean, I think there's probable cause. It's a search warrant. It's his home. The only other people who live there are his mom and his little brother. And then there's also the postings on Instagram of him with these guns.
135,000 of UN's currency. You know they're going to look to seize that. Okay, there's probable cause. The only mistake I see is, no, I think it's all right. Count 1 is $1. Count 2, possession of a weapon by a delinquent, 5 counts. What do you want me to do? Split them all or do one? How do you want it, Ms. F?
Are there different dates?
Yeah.
So
Count
one
1 is 7,500. Count 2 is 7,500. 3, 4, and 5, you want $1?
That's fine.
How many different dates are there though?
Well, there was the date on the Instagram and then this one at his house. So that's 2. that I can tell. Count 3, 4, and 5. I'm sorry. 3, 4. 3, I'm sorry, 4, 5, and 6 would be $1.
So the,
Count 7. Possession with intent to sell THC, there's probable cause for that. That's for the vape, $7,500. And count 8, possession with intent to sell cannabis, there's probable cause for that, $2,500. I'm sorry. Do you want count 7? What do you want that at? It's a 3rd-degree felony. 25 count 7 and 2,500 count 8. Excuse me. No Nebbia.
Iana, can you repeat the bonds, please?
Yeah, $1 count 1, 7,500 count 2. Count 3, 4, and 5, $1 each count. I'm sorry. Pardon me, I said it wrong. $1 count 1, 7,500 count 2, 7,500 count 3. Count 4, 5, and 6 are $1 each. Count 7 is $2,500. Count 8 is $2,500 with no Nebbia, and I'll see this judge tomorrow. Have a nice day. Next, we have Richard Jenkins. You have Mr. Jenkins there, please? Oh, hi, Ed. And she's back. Who needs a Creole interpreter? Corrections, you have anybody that needs a Creole interpreter? I have one here.
Number 44, page 15, Junior Exilus.
Okay. In the meantime, where's Richard Jenkins? Is he coming over?
He's coming in, Judge.
Okay, thank
He just needs a moment, Judge, but he's on his way in.
you. Okay. Thank you. After that, I'm going to take up Mr. That's not the one she said. Who did you say needs the interpreter?
Junior Exilus.
Junior
Exilus.
Page 15.
Mr. Jenkins is present.
Good morning, Mr. Jenkins, sir.
Good morning, Judge.
Sir, you were arrested for failing to register as required by law. I will appoint the public defender's office for you. There is probable cause for the charges. It says when the officer went to go check your house for a report, it was a boarded up residence. There's probable cause. Bond is $2,500. Have a nice day. Next is Junior.
Let's head back to Texas in our continuing efforts to bring you 9 to 11% more Judge Boyd. Let's say good morning to Judge Boyd.
Court is calling 2025 CR 009134, State versus Sonny Robledo. Can I have parties announced?
Megan Dowley for the state.
Abelardo Garza for the respondent.
And are you Mr. Robledo?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. I need your bar number on that, please. Mr. Robledo, did you review the true bill of indictment with your attorney? Did you understand it?
That is my bar number, Judge.
I think it. Oh, it's yours. Sorry. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Robledo, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Robledo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a U.S. citizen, you can be deported, not allowed re-entry or denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under 1244 to 180 days in the Bexar County Jail. There's $180 restitution to the Texas Department of Public Safety. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
State offer states one in attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will review the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on your behalf of your client?
Your Honor, we just asked the court follow the agreement.
All right. The court will follow your agreement. The court will sentence you to 180 days in the Bexar County Jail under 1244. There's $180 restitution to the Texas Department of Public Safety, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. It appears that you have a drug problem. Only 1 or 2 things are going to happen if you don't change your life. Either you're going to end up in and out of somebody's jail or in and out of somebody's prison, or either somebody's going to have to identify your body because the last time you use may be the last time you use. When you're released from the jail, if you can't find a place, a sober support house, or some place to help you with your drug addiction, if I'm still here, you come back here, I'll pick up the phone, call somebody to help you, all right?
Yes, Your Honor.
All right, good luck to you, okay?
I appreciate you, Your Honor.
All right, thank you.
Thank you. I will be
You're welcome.
excused.
Yes.
All right, let's go back to Judge Stevens. Let's not, because just as soon as I go there, he deletes his feed. I hate when that happens. Let's stick with Judge Boyd.
Hello, Mr. Vasquez.
Buenos días.
Good morning.
Oh, buenos dias. ¿Cómo está?
Bien.
Don't. Oh, bien, très bien. A2? Okay, I'm trying to learn, people, so don't get on me for my accent or lack thereof. All right, so your case is being recalled for November 3rd. That is your plea deadline date. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date will be a jury trial date. Do you understand?
Yes.
All right, well, that's all. Thank you. And if my Spanish is not very well, you can blame your attorney. He's supposed to be teaching me.
I'll try my best.
Yeah. Thank you. Anyone else ready?
May I get a seat with this?
Thank you.
All right, let's head back up to Judge Simpson.
On both counts. Thank you, Your Honor. We acknowledge receipt of the information and waive formal reading. Enter plea of mute at this time. Defendant having waived formal reading standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30, Judge Slay. Thank you, Your Honor. Bond continued. Thank you.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case of the people versus Dwayne Stevenson.
Good morning, on
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir? Dwayne Stevenson. Thank you.
Your Honor, I believe I have all of the preliminary, the discovery in this matter. We ask the matter be set for a preliminary examination.
People have their witnesses available the 30th. All right. Preliminary examination. We set September 30th, 2025. 12 noon. That's before me.
I'm sorry, did you say 12 noon, Your Honor?
Yes, sir. Bond will continue. Thank you. Court does call the case of the people versus Abdel Motion Osman. People versus.
And good morning, Your Honor. Brandon Bird on behalf of Abdel Mosen Osman.
And Ashley Feltus for people in both cases.
Brown, case 25 F2 1031.
Your name, sir? Osman. All right. What are we doing?
Examination. Set preliminary examination and
Is discovery complete?
yes, Your Honor.
Mr. Bird, what do you wish to do?
Please, to set the preliminary examination, Your Honor.
Discovery is complete on your case.
As far as I know, Your Honor.
People have their witnesses available on the 30th.
There are two possible go one more week.
Any objection from either side on that?
No, Your Honor.
No, Your Honor, that would be the 6th.
That I think it would be the 7th. Will that work?
It'll work, Your Honor. Thank you.
Preliminary examination in both these matters will be in person October 7th, 2025, 9 a.m. before Judge Freshour.
Thank you.
Thank you.
Fine, thank you. Bond will continue. Thank you. Court does call the case People versus Manuel Hunt. That one I see.
Yeah, no, I got it.
Mr. Bird, you want to state your
Yeah.
appearance?
Sorry, Your Honor. Yes, Your Honor. Good morning again. Brandon Bird on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Manuel Julius Hunt.
All right, what are we doing in this case?
Respectfully, Your Honor, I would like to ask for adjournment in this matter just to get all the discovery. Actually, I just got all the discovery yesterday, but we have a chance to go over it and go over it with my client.
Right.
Your Honor, no objection to the adjournment. If there's any discovery that's outstanding, feel free to contact our office and I'll make sure you get everything.
All right.
There's also another matter, Your Honor.
Yes, I have 1 in 3 weeks, council, which would you, well, I have the 30th. I can set it for that date. Will that work for you?
The 30th will work. Yeah, the 30th will work, Your Honor.
All right.
Thank you.
Probable cause conference will then be adjourned. This is a Tuesday to September 30th, 2025, 9 a.m. Yes.
Your Honor,
Thank you, Your Honor.
Hang on. Go ahead. Yes.
Your Honor, I received information that this defendant has made, as of when we last checked, 19 calls to the victim. I'm sorry, since being arraigned, 19 calls at her listed phone number from his kin as well as other inmates' kin. And the communication is quite varied. There are a lot of calls. There are several concerning statements, though, regarding getting on her by why she's not getting out, talking about that this needs to go away, and so on and so forth. And I'll make sure I share all of that with defense counsel. However, at this point, we would ask that his phone privileges be revoked, and if he wishes to have a hearing, we need a bond violation hearing.
Your Honor, we could definitely address the bond hearing on September 30th, but I haven't received any of these phone calls or any of this information to be able to have a valid argument against the prosecution at this point. So I respectfully ask to keep his bond the same until I have the evidence in front of me and I'm able to be on equal ground.
If you wish to have a hearing, certainly the court will grant you that, but at this time, based upon the representation, I'm going to revoke the defendant's phone privileges. His bond and all other aspects will continue, and then we'll see you on the 30th. Thank you.
Thank you, Your Honor.
The court does call the case of the people versus Gabriel Shawaka.
Good morning, Your Honor. Tina Sachs on behalf of Mr. Shawaka.
Your name, sir?
Gabriel Shawaka.
Thank you. What are we doing?
Your Honor, I'm asking for a preliminary exam date, please.
All discoveries complete.
To my knowledge, it is.
People have their witnesses available on the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court does call the cases of the people versus Annie Oglesby.
I'm about to say, I'm waiting to see the picture from yours. I think I know somebody that's on this. Yeah, so I'm gonna try and call them up and see what's going on with that. I'll say, Shamar, no, Shamar, maybe here. I'll say somebody.
Okay. I don't have an order on the 15th District Court case. I do have obviously one on the other case. But.
Okay. All right then. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Oglesby.
Hi.
Can you state your name?
And you're Annie Oglesby.
All right. Thank you. All right. I have all counsel here for the record. All right. What are we doing?
So, Your Honor, today is the date and time set for a probable cause conference. I do believe that our office has discovered a conflict in our representation, and we will be moving to withdrawal. So we may need to have an adjournment of this matter for that case.
All right. Saxon, on the one that you are on, what do you wish to do on that case?
Your Honor, we're asking that to be set for a preliminary exam.
All discovery is complete on that case.
The judges.
Yeah, I believe it is, Your Honor. Yes, I do believe it is, Your Honor. I have all video.
People have their witnesses available on the 30th.
I'll try, Your Honor. Thank you.
Preliminary examination, that is in case 1022. A preliminary examination will be set in person for September 30th, 2025 at 12 noon. That's before me. Bond on that case will continue. On the other case,
Anna, what is my client's bond set at in the?
Pardon?
What is my client's or current client's bond set at in the 5753 case?
And it's a 1,000 cash or surety in that case. In the case before you, or that's your office is still on. In the other matter, I don't have an idea. Oh, in the case, because it looks like because of a bond violation, her bond is denied on.
Okay.
Your Honor, I'd like to make a bond motion in regards to that.
Hang on. In your case, Mr. Brown, I'll adjourn the probable cause. I'll just go 1 week out to 25th.
Thank you.
September 25th, 2025. 9 a.m. Well, actually, why don't I just go ahead? I'll just do it the 25th. And I'm presuming you're going to want to change the bond if there's a change in the other's bond. Go ahead, Ms. Saxon.
Your Honor, we understand the bond was revoked because Ms. Oglesby failed to test. She has arranged for to stay in Ypsilanti and be able to test. She'll be closer than she was living before. So I'm asking for a nominal bond to be set so she can go back to work, get reunited with her children, but also show that she is able to comply with the testing this time.
And for the record, Your Honor, my client has the same issues in this particular case. She would make a likewise request for a nominal bond.
But she is, was she already in, well, but she didn't do anything in regard to the testing. She just didn't do not a thing.
When she got released, she went back to Jackson. She did not have transportation, or more importantly, she didn't have the money to pay. She has now made provision so that she can stay with her in-laws in Ypsilanti. Therefore, it would be easier.
I gave her 2 times to get this done, it looks like.
The first time, Your Honor,
I was incarcerated.
Go ahead.
The first time, Your Honor, she was incarcerated in another county, and there was just a miscommunication. They did not know she was there, so she could not comply the first time.
Right. So when she came down, I said, then you need to go to testing, and she didn't do it.
I think that was a transportation issue.
Yes.
She did say that she would call and was unsuccessful and it would get anything done that way.
Motion for bond reduction tonight. I'll reconsider it at the time of her exam, but at this point, I'm going to deny the motion. On both cases, the bond will continue in both matters.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Taylor Adams.
Ashley Feltus for the people.
Assistant Public Defender Jay Bell, on behalf of Mr. Adams, who coaches. Mr. Adams, can you please state your name for the record?
Taylor Adams. He's waiving.
He is waiving, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following. Mr. Bell.
Your Honor, we acknowledge receipt of information. We formal reading, stand mute at this time.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
November 18th at 1:30 with Judge Conkey.
November 18th, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Go.
She needs to stop.
All right. Continuing to bring more Judge Boyd. Let's go back to Judge Boyd.
All right, so did he provide the $1,000 towards restitution?
He has 900 of it, Your Honor. He doesn't have the 1,000.
Okay, why are you short $100? I'm sorry?
That I just had
Why? Like what happened with your budget?
and get, I only get 9,900.
All right, and who's the prosecutor on this?
He wasn't exactly sure where to pay it, so he has the money order today. He just doesn't know what department to give it to.
All right, so he has $900 money order,
That's correct, Your Honor.
and state, where does he need to give that?
Judge, after conferring with probation, I'm gonna fill the form out and then he's to take the money order to the first floor of the DA check section.
Okay, and then my other question is, how much is he going to be able to pay monthly towards his restitution?
Well, I got a job with the company, the tree service company.
Mhm.
So they pay me, right, probably contribute every month.
Well, how much?
Do you think you could do like $500-600 a month?
Probably, yeah.
See, here's the thing. How old are you?
20.
All right, you're still sort of young. Don't tell me what you think I want to hear. What I want to know is how much you can pay per month towards restitution. Do not pull numbers out of the sky because you're like, oh, let me say $500 a month because I think the judge would go along with this. Because let me just tell you, if you tell me you're going to pay $500 a month, you're going to be paying $500 a month. And if you're short, what's going to end up happening is I'm going to get a report with probation. So have you sat down to figure out what your expenses are, how much money you have coming in, and how much you can really pay per month?
No, I do not.
All right, so they're going to get a form for you to fill out, and I want you to sit down with your attorney and come back to me when you're ready with how much he can realistically pay per month. Now, what I can tell you, $50 a month is not going to work for the court. So it is going to be more than $100 a month. You understand? Because they want their money. All right. All right, thank you. Yeah, and just let me know how much he says he can pay per month. Are we ready on anyone else?
Probation be providing you that form, or did you just?
Oh, the state will have that form.
Oh, you're talking about the restitution forms?
Yeah, then his $900 to give to them.
Oh, okay.
And then he needs to sit down right now and let me know how much he can pay per month towards the restitution. And then I'll take up sentencing.
All right, something tells me he may have to give up his Starbucks for a while. Let's go to Louisiana.
25. The time is 9:04. My name is Carolyn Stapleton. I'm serving as the chairperson today. My colleagues on the panel are to my left, Chuck Tillis, and on my right, Jerry Ledoux. The panel today is at DOC headquarters in Baton Rouge, Louisiana. Headquarters staff, please introduce yourself for the record.
Francis Abbott. James Cavalier.
Today, our remote location is at Raymond Laborde Correctional Center. With the staff at that facility, please introduce yourself for the record.
Brent Thompson, Warden. Steve Bordelon, Deputy Warden.
Nikki Shinver, Deputy Warden. Raven Heath, classification. Melissa Joshua, records.
Thank you. Mr. Angel, please introduce yourself by stating your full name and DOC number for the record.
My name is Lee Jules Angel, DOC number 240608.
I will give you a brief explanation of the process. I will read some information into the record and ask you to verify it. We will give you a chance to speak and tell us what you did that caused your incarceration and why you should be released. Then the warden at the facility can speak. We will allow public comments from 3 supporters who will speak on your behalf and 3 people in opposition. will be allowed to speak, the district attorney, and then we also have people from the AG's office here and Louisiana Department of Justice. They will give their statement. Then we'll conduct a parole interview, and your case has been assigned to me, Carolyn Stapleton, who will take the lead in your interview. So we're going to start with that. Today we have for parole interview consideration Lee Angel. He stated his DOC number as 240608, who is a first-class felony offender, and you were convicted of forcible rape, second-degree kidnapping, armed robbery. Your parole eligibility date is you have none, and your good time date is you have none. Your parole eligibility date.
That's a good thing.
Parole eligibility date is 8/1/2021. Okay, your good time date, do you have that or no? Okay, 9/5/2044, and your full-time date is 5/22/2070. Is that information correct, sir?
Yes, ma'am.
Okay. Okay, Warden, do you have anything you would like to say about this case as our inmate?
Currently he's doing pretty good. He's actually enrolled and he's actually working right now in our small engine program. His disciplinary record is not too bad. His last writer was in 2018 for rule number 5. He's not doing too bad at this time.
Okay. Okay, would you like to tell me what brought you here today? What was your crime, sir, Mr. Angel?
Ma'am, I was leading a really bad life, not stable, working on riverboats around bad people. And I did not want to wait for my checks to get together to be able to have me a new life. So I decided to get me a gun. And I knew where they had one of my stepdads. So I got me a screwdriver, got on a bicycle, went to the house to get the gun. And his daughter happened to be there, and my mind clicked, put her in the car, and we took off. And when I tried to go rob the people I wanted to, nobody was there. And I just lost my mind, and I realized I'm going to prison. So I went ahead and forced her to have sex, and we rode around, robbed a whole lot of people. I robbed gas stations from gas money, trying to figure out what to do, until we just rode on till late at night. And that's when we got arrested, finally caught up with me. That's basically what happened that night.
You had a co-defendant also, didn't you?
Yes, a young man, I think he was like 16. I just picked him up, knew him and his whole family. And I told him what I was going to do, and he was all right with it. I said, well, let's go then.
And he raped her also, right?
No, ma'am. That's strictly me. He just riding in the car. All he did was ride in the car.
Okay. All right. Does your attorney, would he like to speak at this time? Do you have an attorney?
No.
No.
No, ma'am. No attorney.
All right. So,
He does have family members here.
okay. All right, so we're gonna go to, I'm sorry, I can't pronounce the last name. That is, no, Degator, is that person here in support of friend?
He's supposed to be on Zoom, I think. Yeah. A friend of mine. On Zoom. He's on Zoom. I don't see him. But he's a friend of mine, childhood friend. Be Dignitary.
Oh, okay, well, he's not speaking, so we're gonna move right along.
Yeah, I have my AT here, would like to say something though, ma'am.
Okay, you can go ahead and speak, ma'am. What's your name for the record?
My name is Katrina Collette.
Okay,
I'm Lee's maternal aunt. His mom was my only, one and only sibling, a sister. We lost her in January of this year. I've known Lee all of my life and I've watched him grow up. He was never a bully or a mischievous child. He lost his dad when he was almost 15 years old, which is a vulnerable age for any child. Everyone who knew Lee couldn't believe what he had done because this was not the Lee we all knew and loved. When he turned to drugs, that's when his life turned around. He was only 25 and on drugs, and when he went to prison, he is now 55 and has become the real man, clean and sober. In the 30 years he's been in prison, I've watched him mature into the man he is today. He has overcome illnesses more than once, where the doctors told us at one point he only had 18 months to live. I believe God has work planned for him in the free world. He has taken classes in the past, facilitated classes, and has recently earned certifications in different areas of mechanics, small engines and diesel, and in theology. He also attends AA meetings. He knows what he did was wrong and is remorseful for it. He has built a relationship with God and has helped others to come to depend on God to show them the right path to take God is forgiving and he wants us all to be forgiving as well. All he wants to do upon his release is to work and enjoy sleeping in the dark. He isn't scared of hard work, and the heat or cold would not be an issue after being in prison in the summers and the winters with the heat and the cold. He's learned how to cope with many situations while being incarcerated, and I feel that he can deal with hard situations he may find in the free world. He's clean from drugs and wishes no ill will toward anybody. He just wants a chance to live free for the remainder of his life. I don't know where his stepsister lives, but I do go to Lafayette all the time and I've never met up with her. She has a good life with her husband and children and has nothing to change if Lee comes home. I'm sure she can go about her life without ever seeing him again. His freedom would cost them nothing. Living in Lafayette, they're more in danger of strangers than they would be from Lee. My family of 3 sons and their families would like to have Lee be part of our family again. I feel that Lee has been in prison long enough to have paid his debt to society and to his stepsister.
thank you very much, ma'am. So today we have an opposition. I'm going to call Howington with the 16th JDC.
Good morning, y'all. My name is Claire Howington, and I'm an ADA with the 16th JDA. I don't believe I've met any of y'all personally before, but I'm happy to be here on behalf of Ms. Royston, on behalf of our office. I'll listen to Mr. Angel's comments, and I have made some notes before this, but I really just want to focus on this first. One of the things I always look at when I think about parole cases is whether or not that offender has really accepted that they made a choice to do something that was wrong and that it hurt someone else. And I noticed when I was going through the pre-parole report that one of his comments in his pre-application is that he was on drugs at the time that this happened. And there didn't seem to be a connection in the way that comment was written between his actions and his drug use. He didn't realize his drug use didn't cause him to do this, his choices caused him to do that. And then I listened to him today, and he talked about being around bad people and going to rob somebody, and he still is downplaying what he did to Ms. Royston, which is an incredible violation. I mean, it's painful for me to think about, quite frankly. And he still doesn't realize that that's his choice, that his choices led him to be where he is. So that always is just a trigger for me that I think he's not quite ready to be somebody who is out in the free world because he doesn't realize his choices are what led him to be where he is. And in that vein, I think that not only was the nature of the offense here heinous, he pled down a life sentence to be where he is now, that in his comments, he just has not had enough time. His full term date is 2070. I'm not good at math, but to me, that's less than half of his sentence. So I think that parole should be denied. He is just not there yet. He has not spent enough time, and it doesn't sound to me like he's truly remorseful. Don't got any questions? That's all I had.
Yes, ma'am. Thank you very much.
Thank you.
She is, okay. And, Mr. Joseph LeBeau?
Yes.
Okay, and you're with the Louisiana District, Department of Justice, I'm sorry.
That's correct. Ladies and gentlemen of the parole board, thank you for allowing me to speak. My name is Joseph LeBeau. I'm with the Attorney General's office here. While we were not involved with the prosecution in this matter, victim Ms. Royston did reach out to us, and I think that's the most important thing that I'd like to discuss today. In Mr. Angel's recitation of his version of the facts, what he failed to mention were specific threats made to the victim. Specifically that if she were to cooperate with law enforcement or if he were to ever get out of prison, that he would cause more violence towards her. I think that is very important for this board to consider to go along with my co-counsel's theme of lack of accountability, lack of remorse. That was not mentioned. Another thing that was mentioned during Mr. Angel and his family's statements were that if he were to get out, that nothing would happen. The victim would just be able to live, continue to life. I think that is a drastic understatement of what the realities of somebody who committed a forcible rape, armed robbery, a rape with threats of use of a weapon. It would cause immense emotional damage to this victim if he were to get out of prison and live in the same area that she resides, knowing that they could run into each other at the bank or at a grocery store. So I agree with my co-counsel. I don't think there's been enough time. I think the more appropriate remedy is to allow Mr. Angel to serve until his good time date, which is in 2044. And so I would ask the full board at this time to deny parole today.
Okay, thank you very much. At this time, we're going to go into executive session.
I'll make the motion that we go into an executive session.
Second.
Magoo?
Yes.
Pennington?
Yes.
Gillis?
Yes.
All right, we'll come back to that for the final ruling. In the meantime, we'll go back to Judge Boyd.
2025 CR 003287, State versus Christopher Vincent White. Can I have parties announced?
Rick Pena for the state of Texas.
Doug Campbell for Mr. White.
And are you Mr. White?
Yes, Your Honor.
Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. White, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. We will waive the repeat offender enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen By entering into this plea, you could be deported, not
Yes.
allowed re-entry or naturalization.
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Lenea, Lenea, Laralde, Larralde. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge, with
State-
one change,
Yes.
believe, Ms. Rinaldi now goes by Ms. Bland,
I'm sorry, the last name?
last name Bland,
BLAND?
B-A-L-A-N-D, yes.
All right. State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the BIPP, cap evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So, with regards to this plea bargain, I don't see why I should follow the no harmful or injurious contact. Why shouldn't it just be no contact?
I can address that.
Yes.
Mr. White and Ms. Bland, who's sitting here in the front row, have had a conversation while Mr. White was in prison for the previous family violence charge.
And the previous family violence charge, was that against her?
No.
I could, no.
Okay.
But I think that change of heart has led them to understand that this is not the path that they both want to go down. They are going to raise a couple of children together, and if there is a no contact order, that's going to be an impossibility.
What, are these his biological children?
They are not. They're children that she has adopted. Her
Wait, let's slow a bit. So she's adopted some children. I'm reading this police report that she had been living in a hotel from hotel with these adopted children.
Don't believe they were there.
They were not adopted at that point.
Well, that's true.
So she didn't have any children with her at that point.
She may have, Judge. I think the difference, though, is that having served his time, Mr. White and Ms. Bland are asking the court to allow them to have no harmful or injurious contact. He is on probation still for the other case.
Parole.
Parole, excuse me.
Yeah, I don't think this is a good. I'm not going to follow the no harmful or injurious contact.
Can I talk to my client briefly?
Sure.
Judge, in talking with my client and with this plan, they are okay with no contact.
All right, because here's the thing, you have to internalize what you did. You have someone who's living in hotel from hotel. They're telling you, no, according to the police report, she's telling you, you can't stay with me. And I'm making an assumption that she didn't want you to stay with her because you were not pulling your weight, because she's living in a hotel. And then you come over anyway with your clothes, and then you hit her in the face with a Nike sandal. That's what the police report says. And she had visible redness. So it appears to the court, you haven't learned anything from being in prison beforehand or being on probation beforehand with the
Judge,
previous assault.
this was before he went.
This was previously before I've been incarcerated. I've been incarcerated for a year and a half since then.
I don't think your relationship with her would be a good one. And I don't think you would be successful on probation with that relationship. And I don't think adopted children need to be around that. So any objections? I've heard your argument. What I can tell you, your plea bargain agreement is for no harmful or injurious contact with Linnea. I am actually going to do a no contact order with her. So that is a violation of your plea bargain agreement. So do you still wish to go forward with this plea?
How long would it take to get a trial?
How long, what?
How long would it take to get a trial set?
Oh, we can do it right away.
Okay, ready.
So
Right now?
Probably gonna be next week.
Just go for it.
So what do you want to do?
Just go with the no contact. It's fine.
All right, so there's a $1,500 fine that will be probated. There's an affirmative finding of family violence. There's to be no contact.
Judge,
Yes.
with respect to the TAP evaluation, given the fact that he's been locked up for a year and a half, can you do that without?
Let me get to that. Just give me a moment. So there's to be no contact with Linnea, Laraldi, Bland. Proof of employment within 45 days, no employment as a home health care provider or with minors, no residing with minors. The BIPP course, 100 hours of community service restitution, TAP evaluation, out of custody, follow recommendations. If you miss that TAP evaluation appointment, that's going to be a violation of your probation, you understand?
Yes, Your Honor.
Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person, regular random UAs.
One other thing,
Yes.
with respect to the requirement for employment, my client does have a disability.
All right, so what's your disability?
I'm MHMR. I have bipolar and PTSD. I have
Alright.
ADHD. When I have a stipulation on my parole that I have to go through special needs program, so I'll be having to do programs for that.
All right, so it's going to be proof of employment within 45 days or SSI within 45 days. MIC evaluation, out of custody, and referral for Center for Healthcare Services. Probation, is there anything else? Is there anything?
The length of deferred, Your Honor?
Oh, thank you. 3 years.
I'm sorry, Judge.
No, it's my fault. 3 years deferred adjudication.
Judge, our agreement was 2. We just.
No, that's not a part of the agreement.
This was.
Sure. Okay, sir.
All right, 3 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
Thank you.
Thank you.
All right, let's head back to Louisiana and see how this finishes up.
And it's at 9:30 a.m. A motion?
Make a motion, we return.
Okay. Okay, so we're back. I'd like to know from, Mr. Angel, you can speak now and tell me, if you could speak to your victims, which like you said, you admitted to, you had many that night. What would you say to your victims?
I would tell my victim, it's not a targeted thing. She was just not what I went for. I went for the gun. It was not personal. It's not something intentionally for her. It was not something that was meant to be. I didn't really mean this at that time. Just realizing that I was going to go to prison for the rest of my life. And I just seen her, I said, well, this is what I gotta do. And then, after I rode around, that's why I rode around so much, just trying to, felt so bad for what things I was doing. That's why I just rode and rode all night, trying to find an end. I just couldn't find an end, couldn't live with myself at that point. I knew at that point I could not even, I don't have the heart to kill myself. And that's really what I wanted to do that night after I realized what I had done. But she was not a target. I did not go for intentions for her. Intentions was for the gun. That's all my intention was.
So why do you think we should give you an early release? Because you did make a plea bargain that could have been life and it was pled down and you agreed to the plea bargain. So why do you think that that should be overturned as far as you getting out early?
Now I do value life. Other people's in my own. Back then I did not have value of life. Now I have skills and I took classes that helped me with a future that I know I could have. A better life. It's something better than I had before, where I wouldn't have these thoughts in my head to do things. I will be able to have what I need to go on.
Okay, well, I have that you out of a 75-year sentence, which of course, you do have a concurrent, which was another 75 years, which would have been 150 if they were consecutive, that you've only served about half of it. So I did want to mention that. And I do want to mention because I was a law enforcement, I was a victims advocate, I was on the crime victims board, and we had a situation. And your sister mentioned that the victim of the rape has a good life and everything. And without speaking to that person, I would like you to know that we had a case that came up and the guy had raped this woman and threatened to kill her. And he was getting out after 20 years. She moved forward with her life. But then all of a sudden, her case came before us on the Crime Victims Board that she needed counseling and she was falling apart. And it was because he had said, if you ever go to law enforcement and you tell them what I did, when I get out, I'll kill you. So all of that came rushing and flooding back into her life. So you're wrong when you think that victims, even though they move forward, and thank God they do, sometimes they just have to put it in the back of their mind until circumstances like this make it come rushing forward. But were you to be getting out, and whenever you do get out, she will have another thing that she'll have to deal with, and that's the armed robbery victims and the rape victims, all of your victims. They will have to contend with reliving the situation over. So no, I mean, they go forward with their life, but it is never the same. Does anybody have anything they'd like to say? Any questions?
I have a question.
Okay. Well, at this time, the panel is ready to vote. And my vote is going to be to deny. You served around half of your sentence. You did make a plea bargain. And so you got a break there. The victim and victims, if you were to get out, I don't think they would be very comfortable right now. And you said that your plan, your sister said, is to go back into your hometown. And of course, that would never be possible. I mean, I would never approve that. Can't go back there. I think you minimized and you continue to minimize what you actually did to them, because you keep saying that you were just, it's almost like you were having a bad night. And these are the things that you did. So I don't see any remorse. Does anybody have anything they'd like to add? Okay, so my vote is to deny.
My vote also is to deny because of not enough time served in law enforcement and family opposition.
My vote is to deny parole based on, still a lack of remorse for the victim. Time served is way less than 50%, and law enforcement opposition. So my vote is to deny.
So today, your parole has been denied. It's 3 of 3 that have denied it.
Denied. Thank you, as always, to Michael Groff for those wonderful sounders when we visit Louisiana. Let's go back to Judge Oakley. Let's make that happen. Let's do that.
When you're ready, Heather, and I'll tell you what we're doing.
Hold the brand. You want to step up to the podium, please?
Do we got a plea form yet?
Sorry.
Do we have a plea form?
I can write
just
one
tell
up.
them. Go ahead. What is it, Mr.
So
Urkel?
on Hildebrandt, we're amending the charge of fail to stop and identify after a property damage accident to fail to report an accident.
Yep.
And we're amending the civil infraction improper passing to impeding traffic with a $200 fine.
Yeah, and is it all right with you if I only process one file and just hit him harder, $200 harder on that one file?
That's fine. That's fine. I'm fine with that.
Okay. All right, Mr. Hildebrandt, are you going forward today without benefit of an attorney?
No, I am his attorney, Your Honor.
Oh, I didn't know that. Okay. Go ahead,
Yeah, I'm his
counsel.
attorney. Yeah, Stephen Mamet on behalf of the defendant, Your Honor. Today's daytime set for pretrial in this arraignment pretrial in this matter, a waive a formal reading of the charges, and stay on mute and proceed to the pretrial, Your Honor. I had a chance to speak with opposing counsel Greco. He's agreed to dismiss the original charges. In exchange, my client will be pleading guilty to one count of failure to report with an added, the court indicated, added $200 fine in exchange for the dismissal of all the civil infractions.
Thank you. Mr. Hildebrandt, did you discuss your rights and options with counsel today? Did you discuss your rights and options with your attorney? Did you understand all those? You understand the possible penalty for fail to report, the added charge?
Yeah.
Understanding all of that, are you pleading guilty to that charge freely and voluntarily? Counsel, would you like to voir dire Mr. Hildebrandt to get me the facts to support the plea?
Sure. On the date and time
Showing
of
an
question,
incident date of April 21, counsel.
sure. On the date and time of question, were you in this jurisdiction of this court? Mr. Hildebrand?
Were you in the
in
city of
juris-
Romulus on April 21? Go ahead, counsel.
And in that time, were you involved in a motor vehicle accident? And did you fail to report that accident to police?
Yeah.
Okay. Is the court satisfied?
I'm satisfied if you are.
I am, Your Honor.
All right, I'll dismiss both the original charges. What should I consider before I set the terms of sentence?
Your Honor, this was just a lapse of judgment. He got scared and made a bad decision. He's apologetic. Obviously, he's been engaged with this firm since the beginning, and he feels bad, and we'd ask that you just assess fines.
Yep. Are you working, sir?
Right now.
All right. Where are you employed?
Well, they're calling my crap, but it shut down.
How long were you there? Holy cow. And when did they shut down?
June.
All right. All right. Anything you want me to consider before I sentence you? All right. All right. As I said, I've dismissed the original charges, fines and costs on the added charge, $400. Can you pay that today?
Yes.
All right. If you go downstairs, they'll call you up to the front counter. The cashier will smile when she takes your money and get you out of here. Thank you,
Thank you, Your Honor.
counsel.
No, have a good day.
You're all set, sir. We're going to computer it downstairs.
She's waiting for me. Heather, did Mr. Mamet?
All right, let's Let's go back to Judge Glazer because it's now a half an hour past lunchtime and she's still working. Let's see how that's working out.
So it looks like he's a security guard at this club and just beat this guy up and somebody else because he wouldn't leave.
Parece ser que él es un guardia de seguridad en este club y le dio una paliza a esta persona y al otro porque no se iba.
Sir, you are ordered to stay away from the alleged, oh, there's two victims, I'm sorry. Oh, I think, yeah, there's two victims.
Sí, hay dos víctimas.
1 minute.
Minuto.
So victim 2 had a ruptured tricep tendon on his left arm.
I'm sorry, I couldn't hear you.
Victim 2 had a ruptured tricep tendon on his left arm.
Y también tenía un tendón que se rasgó, un tendón tríptico.
Stay away from the victims whose initials are F, F, and DC. No contact with them, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede usted tener ningún tipo de comunicación ni contacto con las supuestas víctimas con iniciales FF y DC. No puede usted comunicarse con ellos ni por escrito, ni por teléfono, ni a través de terceras personas.
And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times.
Y tiene que mantenerse alejado de la víctima en lo que se refiere al lugar de empleo, a la casa donde viva y también escuela.
All right, count 1, there's probable cause for aggravated battery. It's a $7,500 bond. Count 2 is probable cause for felony battery, $5,000 bond.
Entonces, en el primero son 7,500 y en el segundo son $5,000 de fianza.
All right, good day, sir.
Tenga usted buen día,
Next,
caballero.
Jonathan Anderson. Sir, good afternoon. You were arrested for retail theft with a prior conviction. I think the correct charge should be petty theft with a prior conviction. I will appoint the public defender's office for you. So he's stealing milk, cookies, and a toy from 7-Eleven, and he has prior convictions. I don't know what the state wants. Anything recent? Not Miami. I mean, I'm okay with TAP. I don't know what you want.
TAP's good.
Sir, you are ordered to stay away from the 7-Eleven store at 3199 Northwest 62nd Street in Miami, Florida. You're not allowed to go to that 7-Eleven store and you must stay away from there. Do you understand, sir?
Well, why is that? Because I didn't take anything. I actually.
Okay, I'm not giving him TAP. I'm setting a bond. It's going to be $1,000. Have a nice day. He's not a good.
He has no issue with the order, Judge.
He has no. Yes, he did. Why is that? I didn't take anything. He
So
means he's
just
going to go
because
back to
he's
that
denying-
7-Eleven.
He understands he cannot go back to the.
No,
7
you understand. He doesn't.
No,
Miss
I
F, does he have
understand that. I'm trying
priors
to
in
go my
another
proper
county?
He said
way.
he understood.
I'm
Yes,
just
Miss
trying
F,
to go
does he
my
have
proper
priors in
way.
another county?
Let me see.
I'm trying to go
No,
the
I don't
proper
think
way
so.
to understand. You can't just say.
I don't think so.
All right. TAP alternate bond, it will be $1,500. Stay out of that 7-Eleven, sir, and don't get rearrested because if you do, you'll be locked up in jail until the trial. Have a nice day.
Future court date? The Oh, no. 20th.
The arraignment date is October 20th at 9 a.m. Courtroom 2-3, Judge Gamez.
Corrections, do you have any idea how big the afternoon is?
No, we don't have the calendar yet.
We're done. We'll see everybody at 1:45.
Okay, thanks, Judge.
Just in time, I think. She needs a break. Let's try again in Louisiana.
Day and why you are seeking an early release.
mitigate to admit to a crime that I got involved with, a senseless and cowardly crime I got involved with in 1992 that resulted in a drug deal that led to a man losing his life and one man was injured. And I foolishly, it was no excuse. It was my decision. I mean, I knew right from wrong. I knew it was wrong. And I don't know what got into me that night. I just foolishly made that decision to be involved in a crime that led to two people being shot. One man lost his life and another one was injured. And the third victim that wasn't injured, it's a blessing she wasn't injured because she and I was classmates at elementary. So I was relieved to know that she wasn't injured. I'm sorry for what happened. What happened should have never happened. And I'm truly regretful that it did happen. I'm regretful. I regret it. I've been regretting it for many years. I mean, when I was in solitary confinement over the years, for 10 years, I mourned many nights asking for forgiveness because what happened shouldn't have happened. It wasn't worth it.
Hey, I was supposed to read into the record some information, so I'm going to do that now, Mr. Turner. I listened to everything that you were saying. You're a class 3 offender, is that correct?
Yes, ma'am.
You are, you were sentenced originally for manslaughter and armed robbery, and you were sentenced to 40 years. And then there was another manslaughter charge while you were in jail, is that correct?
Yes, ma'am.
All right. Let's see. Your full term, you have a good time date, you're not eligible, but your full-time date is 6/11/2038. Is that correct?
Right.
Okay. Okay, your parole eligibility date is 10/4/2012, and your good time date is 6/16/2037. Is that correct?
Yes, ma'am.
That's all I have to read. Okay. All right. Warden, is there anything you would like to add?
Yes, ma'am. Keith is doing pretty good right now. His last write-up was in February 2019 for a rule violation of number 5. He works at the facility, does a pretty good job with it. He's one of our walk-audits. He's taken several classes. The biggest thing I could say that Keith needs to obtain would be to get his GED. That's something important. Key thing is to make sure Keith, once he actually do get the opportunity to get out, that he actually stay out. But he actually gonna need those tools. From what I understand, the parole project is willing to actually assist Keith as well, and he still can obtain the GED through those processes.
Thank you very much, sir. Okay, we have supporters for you today. Let's see, Dr. Cheryl Muse, Jacqueline Cheryl Muse.
Sherilyn Muse, Sherilyn.
Yes. Would you like to speak? Yes. You could go up to the podium, please. Yes, ma'am. You're fine, talking right there.
Sister, and I believe that has made tremendous progress, especially from the spiritual point of view. He has shown great remorse for the crime that he has committed, and I believe that we will be wonderful to have him released so that he can, the rest of his life, and contribute to society. There are things that he needs to do. Like I said, he's really lost for his crime. And he has been very supportive of him since his restoration. I have been with some of the and I feel that he can watch what he's going to do to be ready to go back to society. He's ready to participate in church. He's ready to participate in all activities that will cover his role. And I appreciate, you know, if you opportunity to do this. Thank you.
Thank you, ma'am, for speaking. Okay, Jacqueline Muse.
Prepare paper because I have a tendency to stumble.
Okay.
If you would just bear with me.
All right.
Good morning to you guys, officers and members of the board. I am Jackie Muse. I am one of Keith's 5 sisters. We were road dogs as children. We played football in the field, kickball, softball, riding bikes, and basketball at the park, even going to the gym. I'd like to thank you for being here, whether in person or by satellite. Thank you for being in position. Months and even years have passed by. We, Keith's family, has suffered a loss as well as the victims. I would like to apologize for my brother's actions on multiple occasions and also ask the family of the victims to please be forgiving. Now that those years have passed and change has taken place, we're hoping to be able to spend some time with Keith among family, friends, and hopefully some classmates. Keith has definitely expressed remorse for his actions, sorrow for the victims and their family, and he also expresses that he wants to be a mentor to other young men, and he speaks of possibly motivational speaking, sharing about not only how you have at some point fall under submission, whether it be to Allah, God, prison staff, you must humble yourself. And I believe he has. After submission, then you can be dealt with. Keith has unfortunately learned it the hard way. Yes, we grew up in a challenging environment, but we since have learned to trust God and not the fist. We have lost our parents, a sister, and other very close members. This has been hard for us without Keith. We have gained great nieces, nephews, and other family also. I'm asking the board to please give us an opportunity to spend time with our brother. Please allow him an opportunity to prove himself to be a productive citizen, to work and care for himself, to help in rearing his grands and great-grandchildren. My mentally ill sister, who recently lost her husband of over 30 years, has no children and awaits his assistance. Thank you again.
Thank you, ma'am. I'm going to mention, and then we're going to go to Carrie Myers, that Annie Lofton and Petra Lofton are here at headquarters also in support of their brother. So now, Mr. Carrie Myers from the Parole Project.
Good morning, Kerry Myers with Louisiana Parole Project. We're here to let the board know that we've accepted Keith as a client of Parole Project. Should this board grant him parole today, Keith will come to us and live in our residence for a minimum of at least 4 to 5 weeks in phase 1. While he's there, he will go through programming that's going to help him. After 33 years in prison, he's done right at 73% of his sentence. He's going to need the type of reentry support that Parole Project is completely prepared to give to people who have served this amount of time. That's going to include social norms, consumer skills, financial management. He'll be evaluated by our social workers for any specific mental health or substance abuse needs. And obviously, our program is about compliance. It's a voluntary program. And Keith is in working with Keith prior to this hearing, he is absolutely willing to comply to the recommendations. Since he's been incarcerated, he's taken Living in Balance, anger management, victim impact, thinking for a change. He's been involved in AANA, Inside Out Dads. He hasn't had a write-up in the last 6 years. Keith is, even though he was denied in 2023, he's continued the same path. We believe that he is now at 57 years old. He's still employable, but he's also has the maturity to understand his actions. And we believe that Keith would be an excellent client for Parole Project. So we would just ask this board to consider the
Thank you, Mr. Myers. Thank you very much. Okay, let's see. At this time, we will conduct our parole interview, and the case has been assigned to Ms. Jerry Ledoux.
Good morning, Mr. Turner. Mr. Turner, you know, you commented about your initial arrest and the situation that occurred to get you into prison. And that was the question that we asked. But I would also like for you to explain your next arrest while you were incarcerated.
Incarcerated. I involved myself with an immoral relationship, and a relationship with me and the victim. We started off as friends, and as time passed, we became more than friends. And the day before the incident occurred, the relationship went left, and things happened the night before the incident. Nothing serious, it was minor. And the next day when we went to work call, I tried to resolve the matter that we went through the night before. And some harsh words was exchanged, was said from him to me. And I took it pretty hard, and words was changed after that, and one thing led to the next. I mean, it wasn't anything intentional. It's just it happened so fast. I truly regret it. It just, I mean, at that time, at that moment, I mean, it was like I acted out of fear and anger. Fear for my life due to the fact that when I was approached the night before the incident, that's what kind of spooked me out. The way he approached me in my bed area. And that's what spooked me out right then. And then the next day when I tried to resolve the matter, I didn't know what had gotten into him to approach me the way he did the night before the incident. So the next morning when we went to work call, I tried to ease the conversation that we had. I tried to resolve the matter, and words were exchanged, and one thing led to the other.
Which ended up with you being charged with manslaughter. He received injuries that he died from.
No, ma'am. He didn't die the same day. He lived for like 6.5, 7 days. But
had a symptom which was caused by the injury. Yes.
Yes, ma'am.
I'm very familiar with this case. I actually heard your case in 2014. So I'm very familiar with the case. And I appreciate the things that you have done while you've been incarcerated. I know that maturity comes in prison, and but tell me how you would handle these things now that you're down the road a little bit. How would you handle these situations?
I've grown, man. I've grown to have full control over myself. I did 10 years when I was in solitary confinement in Angola for 10 years, 10 flat years, 23 hours a day. I was able to find myself and humble myself and grow. I've grown to know right from wrong. I've grown to say, no, I'm not doing it. I'm not going. I'm not a part of this. I'm not a part of that. That was a time where I really evaluated myself thoroughly. So 23 hours a day, I was in the cell for 10 years. And that gave me time, that peace of mind gave me time to realize and mourn and ask the Lord for forgiveness for this and that, for the loss, for the life I live, for the sins I've done over the years. And it truly changed me. It humbled me. And the whole 10 years I did in the cells, I was on good behavior. Since I've been here at RLCC, I've been on good behavior. I've changed. I've humbled myself over the years. I don't get caught up in negativity. I'm like a role model to some of these youngsters. Some of these youngsters, a lot of them is coming here with no sense of direction. I mean, sometimes I step up like an uncle or dad and try to tell them when they're wrong or they're doing something disrespectful. I'm like an outspoken person. I'm always trying to make peace and try to tell a person, a first offender when he's doing something wrong, that don't go like this. You don't do that. How would you like if somebody do that to one of your family members? That don't do that. That don't go like that, son. I'm always trying to talk positive. I'm not a bad person. My parents never raised me to hurt anybody. I'm not a bad person at all. It was just that night, July 31st, I let one of my co-defendants, you know, I guess you call it brainwash. I mean, I had trust in him like he was more than a friend, like we was brothers, and I made a real costly decision that I truly regret. I'm not a bad person. I mean, before my incarceration, I've had several jobs. I've done positive things in life, helping this person, that person. I'm not a bad person at all. And if I return to side, I would like to be a immediate impact to my children, my grandkids, and their friends. And also, if I have the opportunity from you all and my parole officer, I would like to be a motivation speaker to young kids that may be headed for the fast life or destruction along the way as time passes. I would like to talk to them about the life I live and the consequences, the things you lose, the people you lose, and all the things that you could get caught up in prison, like myself, like I got caught up with in 1998. If you don't think wisely, that could happen. I mean, I made a very costly decision of involving myself in immoral sin.
Let me ask you a question. When you were arrested the first time, you were charged with first degree murder, right?
Yes, ma'am. In 92, yes, ma'am.
And so, and they only sentenced you for manslaughter.
Well, I was charged with first degree murder, but to keep from going to trial on first degree murder, they put an offer on the table, a plea bargain on the table that if they give it to reduced charge, they would drop the manslaughter to manslaughter or robbery.
When you had the manslaughter charge in 98, they gave you a 40-year sentence to run concurrent with what you were already serving, correct?
Yes, ma'am.
Okay, so you got 2 for 1 there. Okay, I don't have any other questions.
Well, Warden, how long has he been there with you?
Let's see exactly when he got here. In 2010.
And what kind of prisoner would you say he is?
He stays pretty busy. Like he actually said, he does affiliate with a lot of the vendors on the housing units. He relates with the staff pretty good. Have a pretty good relationship with the staff here as far as the up-ranking staff. But he does pretty good.
And you think he should get his he doesn't have his GED?
Does not have his GED.
Okay. Mr. Turner, why didn't you get your GED? What happened?
I'm presently enrolled in GED class. I was in it. I had to sign out for medical reasons. I was on pain pills at the time I enrolled in class. I went from one class to the next class. And when I made it to the next class to a higher level, the medical department took me off the pain pills that I was taking to ease the pain. I've been dealing with a sciatic nerve on my left side, my back for over 10 years. I've been on the outside hospital, 3 different hospitals, like 3 times. I've been on several different medications. The last medication they had me on was a few years ago by the name of Neurontin. I was on those medications twice a day, but they no longer give those medications in DOC because offender was abusing that medication. So they took them all off over DOC. But the last medication I was on a medication by the name of Keppra. It was a juice solution. I was taking that. I was on that, even though it was easing my pain. But the doctor took me off because that's a seizure medication. And since then I'm not on any medication, anything, and I have the pain daily. The pain goes down my leg, and with a burning and tingling feeling, it goes down my legs. And so I have to get up out of my class to go stretch out, put my leg up on something to stretch out. I'm being painful. But I did tell the head teacher, that if and when the medical department find a medication, something that ease the pain, I'm willing to get back in school.
I see. What kind of skills do you have?
I'm kind of well experienced. I've worked at car dealerships. I worked at 3 car dealerships, Lake Charles Dodge, Chevrolet and Mercury. I worked at transmission shops. I worked at the Port of Lake Charles in the ship throwing sacks. I worked at restaurants. I was a porter cleaning up after hours. I'm pretty well experienced, sir.
Okay. I have no more questions.
I have no questions. Are we ready to vote? Okay, at this time, Mr. Turner, the panel will vote and Ms. Ledoux will lead off because you are her case.
So Mr. Turner, in essence, you have received a 40-year sentence for 2 murders. I think that releasing you at this time would be inappropriate for the charges that you have received in your case. So my vote is to deny.
Okay, Mr. Tillis.
Mr. Turner, it seems like you've changed your life and trying to do better. My vote's going to be to grant.
Okay, Mr. Turner, my vote today is to deny. You have strong opposition from the district attorney in Allen Parish and in Calcasieu Parish. They feel like you would be a danger to society if you were to get out. That you got a break with the first-degree murder, which you pled down to manslaughter, and then, like Ms. Ledoux said, there's actually been 2 murders. So today, I vote to deny. There's 2 denials, and it has to be a unanimous vote for it to pass. So today, your parole has been denied.
Denied.
So 0 for 2 out of Louisiana today, or 2 for 2, I suppose, depending on your perspective on the matter. So interesting day. We got to see some guy blow up in Judge Mercer's court. Got a little bit of Judge Oakley. A couple of interesting cases out of Louisiana. Glazer getting hangry. So well-rounded day, I would say. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, and back here for the morning show tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. It is Thursday, that's Friday Eve, so go have yourselves a great day, make the most of it, and we'll see you soon. Take care, God bless.